Okay, Miss Foster, you're now a co-host.
Good morning, Your Honor.
Good morning. So, counsel, it would probably be a good idea for you to note in your records that this morning's hearing is being reported by Brenda Foster, CSR number 2470.
Thank you. Thank you, Ms. Foster.
Ms. Foster, we never know what the future holds, and it may become necessary to locate you at some point in the future. And I'm sure the Texas Court Reporter Association keeps records, but for now, would you mind sharing with us where you reside?
Okay, I can write it in this chat. So everyone can see that. Or and then the email.
Chat is fine. Are you currently an official?
No. No, I'm not.
That's
Just
what
a
I thought.
deputy official. Freelancing.
All right, Ms. Foster, I'm sure you're aware, but this is the second day of a pretrial hearing in a case known as Ex parte Ray Falk, Falk Jr., in the 278th District Court of Walker County, Texas. My name is John Delaney, and I am the judge presiding over this matter by assignment. For the state, Ms. Bendel, are you ready to resume today?
I am, Your Honor.
And for the applicant, Mr. Robbins, are you ready to proceed?
Yes, Your Honor. Maro Robbins. That's M-A-R-O for the record. Thank you.
All right, so I have read the emails that you provided to me yesterday about matters that you wanted to try to get resolved today. And I'm happy to take those up, including the state's request to reconsider rulings on the admission of some of the applicant's exhibits that I announced by email yesterday. Likewise, willing to take up this applicant's wish to or request to reconsider the admission of State's Exhibit 25. And then there's a matter of a request to take judicial notice of some materials. I think in order of request, it was probably the applicant asking me to revisit State's 25. I'd like to go ahead and deal with that. I'm happy then to go on to the state's reconsideration of my rulings on some applicant exhibits, and then perhaps then deal with the judicial notice question. If someone has a competing idea, I'm happy to hear it.
That sounds fine, Your Honor. There are a couple other things we would ask to add to the list if it's possible.
And what would that be?
We would ask also the court to reconsider its ruling regarding applicant's exhibit 68, which was the affidavit, one of the affidavits from the jurors from the first trial. And then to also reconsider its ruling in regard to our expert reports. And on that, I'd also ask if the court would hear from co-counsel Bruno Campos, who's here on the expert reports. As the court may remember, this was initially a motion that Mr. Fuller was going to respond to, but he's unavailable today, so we had to split up a little bit. And then just there are also maybe at the end a couple logistical questions we have for the court coordinator about being able to just visit the courtroom tomorrow.
Excuse me, Your Honor. I am very sorry. This is Miss Vindell for the record on Travis Bragg's computer. My computer shut down as soon as Mr. Robbins started talking, and it's gone totally dead. I'm trying to find an alternative computer. I don't know how the sound, and I'm very sorry, especially to Mr. Robbins. I think you've been giving your argument for the last 5 minutes. I was trying to sign back on. Can you hear me all right on this computer?
I can hear you fine.
Okay.
Why don't you try to sign back on? We'll wait. We'll all wait.
Well,
Can you hear me talking while you do that? Because there's a couple of just quick housekeeping things that are not controversial.
the only issue is a camera. I don't know if too low on here. Here, Molly, can I use your computer? I'm gonna have to sign in on a different computer. I apologize. So I'm gonna pop out and then pop back in on a different computer.
Look for that.
Well, can you hear us now?
Yes, I can hear. And actually, hold on.
Well, let's find out what Mr. Robbins.
Is
Okay,
this
we got you
video-
now.
Oh,
We can see you.
okay. I think I'm good then. I am sorry about that. I apologize. I think I'm ready to go. Hopefully nothing else will come up.
Not a problem. Okay, Mr. Robbins, what are the housekeeping matters?
Just, we were wanting to see with the court and the court coordinator, if it would be possible for us to visit the courtroom we'll actually be in tomorrow afternoon, just so we can see sort of like how the technology works to the extent, maybe after lunch. And then the second matter was, in terms of Mr. Falk's transport back and forth, there was a representation we could meet with him in the law library. I guess we were just wondering, are there time constraints on that, time limits on when that can occur? So these are things we can take up at the end.
Well, let's try to get them resolved right now. So, Ms. Fabre, will the courtroom there that we're going to operate from come Wednesday be accessible tomorrow for any lawyer who wants to go inspect it?
Yes, sir. If they'll just check in with me when they get here and I'll take them up there.
Thank you very much.
Where do they find you?
And I'll be on the second floor. That'll be the floor you'll be coming in on where the metal detectors are. And then I'll be right there to your left.
So tell them how they get in the building.
You'll come in through the second doors. Mr. Robbins, you've not been here before, correct?
I don't believe so.
Okay, so you'll come in on the second floor and you'll check in with the security officers right there.
Okay, the building's got 4 sides. What side do they come in?
That'll be on the
East
west side, east side, I'm sorry. And parking, that's, you're just gonna have to find a parking space. So you can park all around the courthouse. But it just kind of depends.
Sounds
Well,
good.
Okay.
Thank you.
Now, in the law library, back to that, that's gonna be dependent on what time security gets him here and what time our security gets here.
In the morning, you mean?
Yes, sir.
Okay. And then how about at the end after court, out of session?
That's gonna be something we'll have to take up with the transportation officers.
Okay. All right. But there is going to be some time provided for us to meet with him after court in the law library.
Well, I have been down this road before with agencies that have custody of prisoners. Sometimes they are cooperative with judicial requests for some latitude. Sometimes they march to their own drummer. We're going to have to play it by ear. And it may become necessary for me to talk to somebody in management at TDC. You know, we've got things like shift changes and all sorts of internal details. Not to mention their concern about custodial security and whatnot. But you've seen the email traffic about why the local jail felt like it could not house Mr. Falk. They only have one, at least at the time the email was written, they only had one solitary confinement room or cell, and that was currently occupied by somebody else. Now, there are other questions relating to this. They propose to get him there at 8 o'clock in the morning, every morning. And goodness knows what time they intend to wake him up to get him prepared to come there. It might buy your client an extra half hour of sleep if we told him we didn't need him there any earlier, for example, than 8:30 as opposed to 8 o'clock. But I will work with you all on those details later on request. Now, if you find out after, I mean, anytime tomorrow, if you find out from him what the plan is, or you find out from somebody else what the plan is, or you already know that you don't want him there at 8 o'clock in the morning, sitting around under the gaze of people who are not friendly toward him, so that it might have some impact on his decision-making process. You get in contact with me and I will do what I can to eliminate the problem. I may wind up having to go through Ms. Fabre, and that's fine.
Thank you. We'll do that.
I recall the last time we had a hearing, in the same courtroom we're going to be operating out of. There was a large delegation of family and friends sitting together on one side of the courtroom, and Mr. Falk was on the other side, the south side of the courtroom. And so you've heard what I had to say on that.
And thank you. We appreciate it. I'm sure it's something we'll probably be discussing in some form or other. But at this point, we don't have enough information. Thank you.
Now, I'm told that TDC is going to provide him with lunch. They don't want lawyers providing him food. That raises a question in my mind. Do they intend to transport him back to the facility, or are they going to have lunch brought or have it with them already?
They should have it with them, Judge, or have it brought over to him. They will not be leaving the courthouse to bring him back and forth to eat.
Okay. So in general, Mr. Robbins, I'm going to do everything in my power to provide reasonable private access between attorney and client. I gather that the TDC officials want to ensure that they have eyes on the man at all times. I had suggested private access in the jury room, but they feel the need to have eyes on, which is probably understandable. Ms. Fabre suggested the county law library, which has glass doors to allow them to be outside of earshot, but still have eyes on. I feel confident there's not going to be any effort to read lips or otherwise overhear what's going on.
That sounds workable. Thank you.
But all that said, I renew my pledge to you to make sure that fair play prevails.
Thank you. We appreciate it.
On both sides, of course. All right, so let's chip away at this inventory of things. I'll remind you that I have a prior commitment this afternoon at 1:30. And if we haven't finished our business by then, I'll be happy to adjourn or recess this matter, take care of my other business, and then come back to you afterward if necessary. So let's take up first applicant's desire to revisit the ruling on State's Exhibit number 25. which I happen to have up on the screen here on another computer.
So yes, thank you, Your Honor. Should I start? I mean, there's not. Are you ready for me to address it?
Well, momentarily, I'm aware that the state had opposed revisiting the ruling. But I will revisit the ruling on both sides. Go ahead now, Mr. Robbins.
Thank you, Your Honor. We would ask to, exclude it at this point because it seems on its face to be hearsay without any apparent relevance. Based on the state's representations yesterday about the transcript from the first trial in this case, they don't seem to think it has much or should play much of a part in this case. This affidavit is solely about that transcript. I also, this is, I guess, aside from a hearsay argument, but sort of take issue with the completeness of it. But
let's deal first with the hearsay objection. What says the state?
Yes, Your Honor. And I would like an opportunity at some point, not maybe right now, to put my arguments from the email on the record opposing the reconsideration, but addressing the court's hearsay argument. This affidavit is not hearsay, and that's because it meets the exception of a public record. It is a statement that sets out a public office's activities. Specifically, it is a statement from Johnny West, who is the court reporter for the 2012 capital murder trial of applicant. As a court reporter for the district court in that case, Mr. West's statement represents a statement of a public office. Per Texas Government Code Section 52.041, court reporters are sworn officers of the court and hold office at the pleasure of the court. Mr. West's statements set out a public office's activities. Specifically, they set out Mr. West's fulfillment of his duty as court reporter to complete the transcript of the 2012 proceedings, preserve them, and furnish them as requested to the parties. Again, in Texas Government Code Section 52.046 and 52.047, that refers to the general powers and duties of the court reporters, which include taking and preserving shorthand notes and furnishing transcripts to the requesting parties. The affidavit merely reflects the dates upon which those transcripts were available. The state's arguments yesterday have no apparent relevance to this because he actually launched the relevance objection prior to any of the state's arguments on judicial notice. And it's not with regard to whether there are certified copies or not. The mere question is availability. They were available, according to Mr. West, at the latest on May 2013. And as he is setting out those duties as a public officer, the affidavit meets the public records exception because it is a statement of a public officer serving in his public office. And the state can also address relevance if Your Honor would prefer, or it can wait.
Go ahead and speak to relevance.
Okay. This court has designated applicant's false testimony claims contained within Claim 2 of his application, and it is issues of fact 10 through 31. One of the issues is whether Mr. Falk could have objected to the alleged false testimony at trial in 2017. The state's position is that he could have, because he mostly relies on the 2012 testimony, and those transcripts were available to the parties starting in 2013. If it is true that these transcripts were available to the parties or that they could have been obtained by any reasonable diligence, then that goes to two separate issues in the state's view. One, it means that the claim is procedurally barred from habeas review because he could have raised it at trial. And that means that there is a contemporaneous objection bar, which is repeatedly upheld by the CCA in both habeas and direct appeal cases. And secondly, if the claim was available, that defines the harm standard that must be applied to the false testimony claims. That is, one of the components of a false testimony claim is that he must show materiality. And if the claim was available at trial, he must also show harmless error. So this is directly relevant to claim 2, which this court has designated for factual resolution.
All right, Mr. Robbins, your response?
Your Honor, this is not a public record. This is a statement prepared for the purposes of litigation, drafted by the opponent, by the state. This is not a record that is produced normally and it is the court shouldn't, it's not reliable. You can tell it's a document for litigation because of what it leaves out. It says at the first part that to the best of my knowledge and recollection, on December 5th of 2012, and at the request of Mr. Falk's defense counsel, I completed the transcript of the motion for directed verdict from that proceeding. They make a point of noting that defense counsel made the request for the directed verdict transcript. They then go on to say, to the best of my knowledge and recollection, on May 7th of 2013, basically I completed the full transcript of the first mistrial. And then it goes on to say, at the last sentence, it was my practice to always send both parties copies of any transcript that I had completed on the day I completed it, regardless of which party requested it. What they leave out in there is that the state were the ones who requested this transcript of the trial. They're the ones who received it. As far as I know, nobody else received it. Nobody had it available. And so this whole relevance claim based on the idea that this transcript was available to Mr. Falk is just false. And what they're leaving out there, I think I would surmise, based on him saying it was my practice to always send both parties, is that he has no memory of doing so and no record of doing so. And that's why he has to say it was my practice. And the reason he has no record of doing so or no memory of doing so, I submit, is because it didn't happen. The state are the only ones who had a copy of this until we got it in the post-conviction proceedings. So I submit to you, this is not a public record. This is a strategically drafted document for purposes of litigation.
So just to complete the picture, does the transcription of the 2012 trial exist?
Are you asking, who are you asking?
I'll ask of you.
Yes, I mean, it exists. We obtained a copy of it from the state in the state's file. It does not appear to be certified. It appears to be complete in all ways, but doesn't have a signature on the pages. I provided a link in the email. I don't know if it's accessible so the court can actually put its eyes on it if it wishes, but it exists.
All right, so let's go back to the hearsay problem once again. What's the state say in response to that argument about it not being an official record?
Yes, Your Honor. Many of applicants' arguments go to weight, not admissibility. If they would like to attack some certain part of the record, they are free to do so. But that does not undermine whether the statement itself is hearsay or not. And it is not, because 8038 says a statement of a public office, if it sets out the office's activities, which undoubtedly a court reporter transcribing proceedings is the office's activities, If it sets out a matter observed while under a legal duty to report, which undoubtedly a court reporter has. So it meets both of those aspects. And as a result, this is clear that he is only making factual statements in the course of his court reporter duties. If applicant believes there's information that's left out, he is free to call Mr. West and ask him questions if he would like. But that doesn't undermine the nature of this document as a statement of a public record.
May I reply briefly?
Yes.
It's not a public office. He's even retired at the time of this is taken. It's not a state entity. It's not a county entity. It's not any kind of organized government agency. It's not a public office. He's a private individual.
What do you say to that? What do you say to that?
That's not how court reporters work. It's a public office while he was reporting, and he's referring to duties he had a legal duty to report while he was currently there. Court reporters maintain that duty whether they're retired or not.
You'll have to lead me through that argument again, Ms. Vendel.
The last
How can a statement made by a person who is no longer the official court reporter constitute an official record?
By statute, Your Honor. The government code makes clear that court reporters are sworn officers of the court. He is reporting in his affidavit as the public officer of the court when he was in that proceeding. He is reporting on duties that he had on matters that he had a legal duty to report. This happens often with court reporters who have retired, for example, especially in habeas cases, especially in federal court, where they no longer are active court reporters. It is still their duty to transcribe and certify transcripts long after they've left office. This happens a lot in criminal cases, Your Honor. It doesn't make a difference whether he is currently a court reporter. The duty maintains.
May I quickly also to that, just very quickly?
Yes, of course.
He is not doing that duty of certifying anything in this. He's making statements that they crafted for their advancement of their case.
By his logic, Your Honor, I'm unsure how then we can ever get certified copies from him.
I'm saying he can certify them. He's just not certifying them here.
So he may certify them now that he is retired about duties that he had in 2012, but he otherwise doesn't have a public office or duty to report?
Because that's what the statute provides for.
Okay, I've made up my mind. I'm afraid that stage 25 falls short of being a government record. So the hearsay objection appears to be good. And I have to exclude it at this time. Of course, the state is always welcome to call this man as a witness.
Of course, Your Honor.
Yep. I'm not sure what all the controversy is about, because in the next breath, the applicant wants me to take judicial notice of the content of this very transcript, but no one needs to address that. I've excluded 25 on purely technical grounds. Applicant said he wanted me to revisit the ruling on states 68 as well. I'll do that.
Your Honor, there is no state 68.
No, sorry, it's the ruling, your ruling excluding R68.
Ah. Okay, what makes most sense, doing that or talking about this judicial notice problem?
I'm guessing this will be quicker than 68 will be quicker than the judicial notice, so it's up to you.
I think you're right. So bear with me while I find 68. Hmm. All right, I have applicant's exhibit 68 before me. What is your argument, Mr. Robbins?
Your Honor, so we're asking the court to reconsider its ruling subject to authentication at the hearing. So in terms of the admissibility for purposes of hearsay, we are not offering it for the truth of the matter asserted. It's being offered to show its effect on the audience, which included the state. It's one of the jurors from the first trial telling them they didn't prove their case the first time around. Additionally, I think there was an issue raised to Rule 606. But this, if I need to address that, this doesn't fall within Rule 606 because, to begin with, that addresses proceedings that are looking into the validity of a verdict or indictment, and we are not looking into the validity or verdict or indictment from that first proceeding. Secondly, the affidavit doesn't address deliberations because there were no deliberations. It resulted in a mistrial before they got to the deliberating room. And it obviously doesn't address a verdict because there was no verdict. Yeah. So for those, it's not hearsay because it's not being offered for the truth of the matter asserted, and it's not barred by Rule 606.
Okay, explain to me what purpose it is being offered for.
To show this is a document that shows that was circulated after the first mistrial, or and its effect. It's being shown for its effect on the prosecution. In other words, it was one of the things that told them they had problems with their case the first time round, and that's why the prosecution failed. And their conduct that the court will be looking at the retrial in 2017 was a response to this information that they had not proved their case and that their prosecution had failed the first time round.
All right, give me a moment while I look at this in a little more detail. All right, state your position.
Yes, Your Honor. As to the hearsay argument or the suggestion that it's not being offered for its truth, it clearly is. But clearly what they need is that they want a juror who believes that the state's evidence was improper. This alone doesn't show any effect on the state. If they would like to ask the state what the effect of it was, that is appropriate testimony. That doesn't admit the underlying document. And the argument that it's not hearsay is a clearly backdoor attempt at hearsay. In addition, it also very clearly is 606B evidence. Applicant's argument is certainly a creative one, that just because there was no actual verdict as a result of a mistrial, that I suppose any juror can come in and talk about anything they thought at any point in the 2012 trial, but that's not appropriate. If they are talking about evidence that they were going to deliberate on and for the purpose of reaching a verdict, that is 606B evidence. And the argument that there wasn't a verdict and that's why it doesn't apply, or that we're not challenging that verdict, we necessarily are. Here we are in habeas, challenging a verdict, apparently using evidence from a different trial proceeding. This is entirely improper, also irrelevant. And also, we believe this is improper opinion testimony. It is not for a juror to come in and opine on whether the state met its case or not. That is what a juror does in deliberations, which is why we keep going back to 606B. The argument's very circular because it's just improper.
I didn't understand your last sentence.
The argument is circular. They say it's not hearsay, but then that pleads directly into 606B. And then if we get into whether it's actually true or not that this juror believed that the state's case was improper, we're back at hearsay. And the reason it is so circular is because any way you look at this document, it should not be admitted. One other note, Your Honor, and I could be incorrect, and please, counsel, correct me if I'm wrong, but I believe all of the juror affidavits were offered only for the double jeopardy issue. They were cited to on claim 5, which this court has excluded from factual resolution in the ODI.
What do you say to that, Mr. Robbins?
They're trying to say that you can only use a piece of evidence for one claim. That doesn't make any sense. That's not the way it works. It's impossible to do that. There are pieces of evidence that go to multiple claims. We're not using it to address whatever they were suggesting that was just excluded. I have some other things, responses to some of the other things if the court wishes.
Well, me track your argument that this is not offered for the truth of the matter asserted, but instead to show that the state had some knowledge of a defect in their case that they used as a way to buttress their case later. The response I had to that is, what does that have to do with the claims in this proceeding? The fact that the state had knowledge of a hole in their case seems to me to have nothing to do with the possibility that they improperly influenced the defendant at the second trial.
I mean, Your Honor, I guess I would say it is part of the full context of the 2017 proceedings that the court needs to be aware of to understand the totality of the circumstances. I guess it is akin to, you would probably heard prosecutors say many times, we need to show you what happened before the misconduct to help you understand and explain and determine whether the misconduct happened. It's the setup, it is motive. And so in that ways, it all tends to support the misconduct claims, and it's relevant. And I think you have no doubt heard prosecutors many times say that for courts to have and juries to have a full picture, they need to understand the proceeding setup. And so again, we're not trying to offer it to show that they did not prove their case, but to show that they knew there were audience members who didn't believe they had proved their case.
All right, what are your other points, Mr. Robbins?
I think, well, wasn't sure I understood the circular nature. I mean, it is not hearsay because it's not offered for the truth of the matter. It is not Rule 606. I'm responding to the 606 because they raised it.
I don't think Rule 606 precludes the admission of this document.
Okay. And then lastly, an opinion, I think it is rationally based on his perceptions from having sat through the trial, which got all the way through close of the guilt innocence presentation of evidence, doing what it was being asked to do. So I don't think it's improper lay opinion.
I agree with that. Anything else you want to say? You're now Travis Bragg, excuse me. Miss Vindell.
Yes, Your Honor, I still disagree that this is a proper opinion. It is not rationally based on just his personal knowledge of things that he saw, felt, or otherwise experienced with his senses. Listening to a state put on a case at trial and then having him opine as a juror in that trial, whether the state did or did not meet its burden, is not proper layperson opinion testimony. Further, again, if we're not offering it for its truth, then what is its relevance? It only matters if that is true, if that juror truly believed that the state did not meet its burden. That is the effect they want to show. They want to show that this juror, in fact, believed that the state did not meet its burden in the 2012 trial, and is the truth of that statement that they want the effect on the state to insinuate. I'm not even sure, Your Honor, I agree with your earlier point. I'm not sure what this goes to. I suppose that they prepped for the second trial more while they had the time to do so. There's always holes in a case. That doesn't mean any misconduct by any way, shape, or form. And if it's going to claim 6, which is perhaps what it's being offered for, though, again, we note that it was only cited in support of an excluded ground in the application. If it's going to claim 6, we're back in the world of, we're just arguing insufficient evidence. They're literally using a juror from the first trial who heard the state's guilt innocence case to say that the evidence in the second trial was insufficient to support the capital murder conviction. That was never a proper habeas claim. This highlights why this type of evidence should not be developed. It is appropriate direct appeal argument, and it is not appropriate to be opening up the proceedings in this way. This is a retrial, Your Honor. That's what they want to do. They want to put on the trial that Mr. Falk waived when he pled guilty.
If I may quickly, we're not offering it regards to claim 6. So that whole part, we're not offering it for that. So they can stay there. What they don't want is the court to see the first trial. You'll see, I think, through a pattern of what they're objecting to are the problems with their case that were revealed by the first trial, by the mistrial. A number of these objections we're looking at, you will see this pattern. And that's including that they don't want that evidence to be before the court.
Well, it is an adversary proceeding, isn't it?
Correct, but they were trying to frame ours in a way that I was incorrect, and I was responding to that.
Your Honor, again, if it's not claim 6 and it's not claim 5, and all it is to show the state, then ask the state. If all they need to know is, was the state aware of potential holes in their case that they prepared for in 2012, 2017, they can ask the state. They've designated 2 of the 3 prosecutors as witnesses. The last one is going first. They have every opportunity to make their case, and they do not need a juror from 2012 opining that he would probably not have rendered a verdict in 2012.
Your Honor, they do not get to dictate how we prove our case. It is ours, I submit, and I think there's probably case law. I mean, that's not specifically on all 4 factual points, but that shows that things are admissible and as non-hearsay for the purpose of showing what somebody else did in response. The fact that they would prefer we just ask them, did you guys know you had your holes in your case, and took their word for everything that their witnesses say, should not guide the decision of what evidence we get to put on.
Your Honor, also, this is still an affidavit. It is itself hearsay. Whether the truth is being offered for some other purpose, everything else has been excluded, including Johnny West affidavit right now, that is an out-of-court statement by someone who's testifying in court about information they believe is going to go to the effect of the listener. They can put on the juror if that's really what they believe.
They're making the argument that we made that, and you rejected on Friday, that because you admitted Dr. Conroy's expert report and they didn't object to it, that therefore all the other expert reports could come in. It's piece by piece.
Well, the fact that it's an out-of-court statement doesn't decide the matter. It's got to be an out-of-court statement that's offered to prove the truth of the matter asserted. All right. It's a close call, but I will now admit applicant 68.
Your Honor, then the state would request a limiting instruction pursuant to the argument that was made. If it is not being offered for its truth, then we request that that is what the court record reflect.
What would be the value of a limiting instruction?
For purposes of future appeal, Your Honor, the CCA is looking at this record. Federal courts are looking at this record. This is going to be looked at forever for the next 10 years. So it's to make the record clear that there is a limiting instruction when it has been admitted. If it's not offered for its truth, that is all it needs to say.
Well, the basis of my ruling is that this out-of-court statement is being offered, as the applicant says, to demonstrate by inference the effect that it had on the prosecutors in the second trial. Is that adequate?
Yes, Your Honor.
So while we are dealing with exhibits, perhaps it's time to shift over to the exhibits the state wanted me to reconsider.
And just,
Ones-
sorry.
My rulings by email about the admission of some of applicants' exhibits. I believe that's what we're talking about. So, Ms. Vendel,
And if I may, just for like directing us before she starts. So I think I'm ready to respond to the ones that most of the ones that she asked the court to reconsider. There were 3 that at this point I'm less familiar with, and I don't know whether we will seek to admit them, and so we'd ask to revisit those if and when it becomes necessary. And those are specifically applicants exhibit 40, 41, and 58. The rest they raised, I think I can address.
you'll have to remind me when we get there. All right, what's the first exhibit or group of exhibits you want me to reconsider the ruling on?
Well, Your Honor, if I may clarify that, then, I mean, these exhibits are currently admitted, but they're not sure they're going to offer them. So are they now temporarily excluded until being offered, at which time we'll make argument? For 40, 41, and 58, I'm confused about the posture of these exhibits. Are they admitted or not offered?
Right, I mean, it's a good point. I apologize. Yeah, I mean, I will do the best I can. Like I said, this was a motion we asked to take up Monday when Friday when Mr. Fuller was here, but if necessary, I'll do the best I can.
We can always revisit. All right, so first exhibit, is it 40?
Yes, Your Honor, we'll start with 40. And of course, if applicant just would prefer to withdraw those 3 exhibits for now and address them at the hearing, the state is fine with that as well.
I mean, I guess it is, I'm not in a posture to really sort of say. I think it could become a non-issue and we could regroup it and figure this out at a later time and move on to the rest that we are prepared to argue. I apologize.
Let's just deal with it as best we can now.
Okay.
I have to tell you that for some reason, I'm getting an error message when I try to put that exhibit on the screen. Windows cannot complete the extraction.
Do you want, I could share my screen and maybe that would help?
The destination file could not be created.
Would you like, I mean, it's not as helpful, but I can.
Not yet. Thank you for the offer. Huh. Didn't have any problem looking at it yesterday, as I recall. Okay. Now we're in business. So state, what is your argument in support of asking me to reconsider the ruling admitting applicant's exhibit 40?
Yes, and for these purposes, Your Honor, 40 and 41 are the exact same argument.
Very well.
They are both, for context, OIG or Office of Inspector General statements, in which it appears an OIG officer is taking a witness statement of a TDCJ officer who is reporting a conversation overheard by Mr. Falk and Mr. Kerr. As Your Honor can tell, likely from my description alone, there are 3 levels of hearsay involved in this document. First of all, addressing the first level, the business records affidavit, arguably that doesn't apply all, because clearly these are matters enforced or observed by law enforcement personnel, which is explicitly excluded from both the public records exception as well as the business records exception to the hearsay rule. But even if we were to assume that the mere fact that OIG officer was taking a witness statement and he had an accurate duty to report that to OIG, which is the only thing the business records affidavit would account for, there is still hearsay within hearsay in the document itself. Officer Richards, who this document is being offered, whose statements this document is being offered for, has no business duty to OIG that would be encompassed within the business records affidavit. He is merely reporting what he saw and overheard, and the CCA has addressed this identical situation in Garcia v. State. And for the court, the site on that is 126 SW 3D 921. Pin site 926. In that case, a witness testified as the custodian of the business records from Bexar County Battered Women's Shelter. The business records recorded the defendant's wife's statements that she had been physically and psychologically abused by the defendant. The court held that the wife's statements contained within those business records are still hearsay. The wife's out-of-court statements, and this is a quote, to an employee at the women's shelter did not lose hearsay status simply because the employee had a business duty to accurately report what she said. Business records are themselves admissible as a business record, but that does not mean that all information from whatever source or of whatever reliability contained within those business records is necessarily admissible. When a business receives information from a person who is outside the business and has no business.
Slow down, please.
Yes, Your Honor, I apologize. When a business receives information from a person who is outside the business, in this case, the business is OIG, and the person reporting is Officer Richards from TDCJ. Officer Richards has no business duty to report or to report accurately. That's why those statements are not covered by the business records exception. They must independently qualify for admission. And if OIG is a law enforcement officer, TDCJ is a law enforcement officer, so we do not get these in as public records. The CCA has made abundantly clear, and the rule itself, 803.8, makes it clear that anything observed by law enforcement in the law enforcement capacity in criminal matters is not qualified under the public records exception. And of course, there's hearsay within even still Richards's statement. Anything he overheard Mr. Falk saying, anything he overheard Mr. Kerr saying, that is hearsay itself. So we have 3 levels of hearsay here. The business record affidavit would arguably, and I'm not even conceding that it would, get only the first level in, which is just the mere fact that OIG took a witness statement. But it would not account for Officer Richards's statements, nor would it account for Falk or Kerr's statements. And as such, we don't believe there's any admissibility in this document, and we would ask the court to reconsider its ruling.
All right, I'll deal with these 2 exhibits before we move on to another. Mr. Robbins, what do you say?
Your Honor, if I understood correctly, I mean, there's a, that it is if I understood correctly, their main argument in terms of Garcia's focuses on 8038, the public records exception, but we're offering these under 8036, where the courts have said that when police reports, law enforcement reports are offered by the defense, they're admissible in as business records under the business records exception. And I can cite Jefferson versus State, 900 Southwest 2nd 97, pin site 102, a ruling coming out of the Court of Appeals in Houston in the 14th District in 1995 that has been cited approvingly since then. And they're looking at a Fifth Circuit ruling. They said specifically, we find the trial judge erred in refusing the appellant's request to admit the police report under the business records exception contained in 8036. So,
may I have the sites again, please?
yes, it is Jefferson versus State, 900 Southwest 2nd, 97, pin site 102. And from the
Okay,
court,
the next case.
that was, I think that case cites a Fifth Circuit case,
Okay,
but you'll see that Smith.
If I may respond, Your Honor.
yes, of course.
That Houston case may say that, but the CCA has said otherwise. In Cole v. State, that is 839 SW2D 798. And the pin signs on this will be 807 to 808. In an en banc opinion and affirmed on rehearing, they have explicitly said that the exclusionary provision contained within 8038, the public records exception to hearsay, precludes admission of a DPS chemist lab reports under Rule 8036. You don't get to backdoor what wouldn't be admissible under 8038 into 8036. They specifically address the question of whether hearsay evidence under 8038 could, quote, nevertheless qualify under 803B or 8036, excuse me, as business records. And they held that it would be inconsistent with the intended effect of 8038 to allow admission as a business record. Therefore, they're inadmissible under both.
So was that a record offered by the state at trial?
Yes. If I may, Jefferson cites Cole.
But that is the CCA's case on this issue, Your Honor. A Houston case doesn't undermine it.
So I'll take a close look at this and issue a ruling later.
And that same argument applies to 41, Your Honor.
Understand. Which exhibit next, Ms. Vindel?
The next one the state will argue is applicant's exhibit 43.
Go ahead.
Okay, Your Honor. On this one, I have three separate objections. I have authentication, double hearsay, and relevance. As to authentication, The applicant has claimed that it's self-authenticated because it has a business records affidavit from an OIG custodian of records. But the state wants to note that there were 5 separate exhibits with the exact same business records affidavit from the same person signed on the same date. And while Your Honor noticed that the business records affidavit in 40 and 41 was an OIG record, Jerry Martin's record is not an OIG record. And yet that is who is purporting to say that they can verify that this was made at the time that it was written, that it is some sort of duty they had to record it or report it, and none of that is true. The only thing the OIG affidavit could possibly authenticate is that it was part of its investigative file. But if what we're getting at, and we are, the truth of the letter, the truth of Jerry Martin's letter and what he said in there and what he believed about his intent, again, we're now in a hearsay problem, as well as an authentication problem. Someone from TDCJ needed to say why we got mail cover in the first place. It's precisely what we did when we offered our mail cover letters in State's Exhibit 16. And as for the hearsay, and again, to be clear, Martin has no business duty to TDCJ or OIG. So the content of his letter, therefore, is not authenticated, and it doesn't come in under the hearsay exception of the business records affidavits. Because it's an improper business records affidavit, obviously we challenge even that getting in the first level of hearsay, i.e. the mere fact that there's a record. But even assuming it is, OIG is not the custodian of the mail. They can't testify that the record was made at or near the time by someone with knowledge. The affidavit only shows that they were given and kept a letter by someone else as part of their investigative file in this offense. And of course, all of Martin's statements are themselves hearsay. So we are talking about several levels of hearsay again in this document. They have argued that he's unavailable because he's been executed, and obviously the state cannot dispute that, but there are only limited hearsay exceptions for people who are unavailable. Those are former testimony, statement made under imminent belief of death, and statements about family history. Jerry Martin's statement that he doesn't believe he committed this crime because he doesn't have a mens rea is clearly not the kind of testimony or the kind of out-of-court statement that is offered under the hearsay exception. They also offered that they meet it under 809-24, which is the statement against interest exception. And frankly, that's a totally irrelevant exception in this circumstance. Mr. Martin claiming that he lacked the intent to commit capital murder is clearly in his interest. In fact, that is their entire claim in ground 6, which this court has allowed development on. And it's frankly laughable to suggest that him denying the mens rea is against his interest, as the CCA has affirmed. Statements that tend more to exonerate than inculpate criminal liability are not statements against interest. And I have a case on that as well, if Your Honor would like it, but primarily it is clear that what they're trying to do is offer the truth of Mr. Martin's beliefs about what he did in that crime. And it is hearsay within hearsay within hearsay without a proper business records affidavit that could even remotely get to what they need from the content of that letter. And finally, as to relevance, again, Your Honor, we've argued this with respect to our motion. What does Mr. Martin's lack of intent have to do with Mr. Falk's guilty plea? We know how Mr. Falk feels about it. We know he doesn't think that he did this intentionally, and yet he pled guilty. If he wants to challenge the guilty plea, that's the proper way to do it. And that's what we're doing it. They're precisely coming to this court and arguing he was incompetent to do so. But we are so far removed from the circumstances of the fact that he pled guilty to this offense, and then he was convicted and sentenced to death by a jury. I'm not sure what Mr. Martin's letters to a separate person have anything to do with this issue.
Okay, Mr. Robbins.
Your Honor, I guess in starting with the authentication, they seem to take issue that with who the custodian of records at TDCJ is. They're saying it's the wrong custodian because it's the wrong department of TDCJ. Your Honor, I don't know for sure, but I would bet that we sent a request to TDCJ writ large that saying to a custodian of records, please give us a business record affidavit regards to this. That's who TDCJ tendered as their custodian of records. I don't think that the matter that it's necessarily one department versus another should underscore that authentic, disproves that it isn't what it appears to be. I think this is sufficient to show that it is what it appears to be. Mail collected on a regular course of conducted business there at TDCJ. As regards to hearsay, I think it tends to show that I guess I would say that it's not necessarily being offered. Well, no, I would say it is being offered for the truth in regard to one piece of our claims, which is the application asserts that the district attorney, Mr. Weeks, made false statements to the defense and the defendant by claiming that Mr. Martin confessed to Mr. Weeks that he had tried to hit Officer Canfield, even though that's at odds with every other known statement, including Mr. Martin's last words at the time of his execution. So this is evidence that tends to show that Mr. Weeks made a false statement to the defense when he claimed that Mr. Martin confessed. It's corroborated by other statements and other records that we'll be talking about. And obviously he's unavailable because the state sought a death sentence against him and it's been applied. I guess I don't think it would be unfair they should benefit from that. And I would say in other respects, in other contexts, we're not offering it for the truth of the matter, but to show, again, awareness on the part of the state. And this is OIG Inspector General, who was part of the investigative team for the prosecution, of the problems with their case, including that there was no confessions, that all the statements from Mr. Martin, whose mental state is very much at issue in Mr. Falk's case, was that this was an accident, an unanticipated accident. So for that respect, I'd say it shows, again, sort of a problem with their case.
Your Honor, if I may respond.
Yes.
Going to the authentication argument, saying that they requested the documents writ large. The problem here is the different departments held totally different roles in this case. OIG investigated the case because it was a prison escape and because the people involved were TDCJ employees. So if what they requested, and that appears to be what is from the face of that affidavit, what they requested was the OIG investigative file that does not authenticate the mail letter that a different department in TDCJ may or may not have been asked by whom, who asked them to cover that letter, who asked them to do that. We don't know any of that information. And that is precisely why one business records for 5 different affidavits, some of which are clearly not OIG maintained materials. They were clearly provided to them by somebody else, is not an appropriate business records exception here. As to the argument about it not being hearsay, or first that it is hearsay, but that it goes to the false testimony claims. Well, first of all, there is no false testimony claim that Mr. Weeks told Mr. Falk about whatever conversation he had with Mr. Martin leading up to the execution. So that's not currently a claim. If they're just moving to the fact of Mr. Weeks's conversation and offering it for the truth, it's not for the truth, that's for impeachment then, in which case it shouldn't be admitted. They would need to lay the proper foundation. Is Mr. Weeks aware of the statements in this particular letter? Is he aware generally that Mr. Martin was denying culpability? If they want to impeach that what Mr. Weeks said was that he went and spoke with Mr. Martin on a particular date, and at that date, Mr. Martin told him something, then they can try to impeach that. But I'm not sure with what a letter has to do in 2007, if I believe the date is correct, could possibly go to that particular statement. There is a proper predicate that needs to be laid if what they are suggesting is that Mr. Weeks lied in one conversation with Mr. Falk when he was reporting a particular event. And if what they're saying is this is true and that's not, then we're back in the hearsay world. And that's not proper impeachment at all.
All right, I'll have to take that under advisement as well. Issue a ruling as fast as I can. What next?
And the next document, Your Honor, is applicant's exhibit 53.
All right, I have it.
Again, Your Honor, as with 40 and 41, this suffers a lot of the same problems. It is very clearly an investigative report by law enforcement personnel. There's not even a business records on this one, so we can't even try to address that, which means that the only hearsay exception we would have would be a public record. And because of that, it's being offered for its truth. It's explicitly exempt from the public record exception, which states that it must set out matters observed while under a legal duty, but not including in a criminal case, a matter observed by law enforcement personnel. We don't even reach the hearsay within hearsay of Mr. Fox and Mr. Martin's statements that Mr. Mascunas is reporting in the course of a custodial interrogation. But of course, if we were to reach those, there's absolutely no hearsay exception for those as well. They don't get Mr. Fox statements in because they are his clients. So there's no party opponent exception. It's not an excited utterance. It's not present sense impression. He clearly had been caught after he had escaped and then was being interviewed by law enforcement. And there's no way that the state would be permitted to do the same at trial. There's no way.
Excuse me, is this exhibit going to come in or not based on the same arguments surrounding 40 and 41?
Yes, Your Honor. Yes, Your Honor. Largely, yes. Just there's one less level of hearsay because there won't be the business records affidavit attached. It's just the report by a Texas Ranger outright relaying conversations from John Falk and Jerry Martin. So yes, the arguments will be largely the same. Additionally, though, we do have a relevance objection on this one. They are literally claiming in their response that, quote, this exhibit goes to a key element regarding the state's ability to prove capital murder. They are necessarily arguing an insufficient evidence claim. They're literally arguing that the state did not meet its burden to prove the elements of capital murder. Again, and as we've argued before, this is not appropriate habeas development. You cannot attack a state's conviction, particularly here where he pled guilty and there is no state's presentation to attack. But if they're suggesting that he lacked mens rea, that is an insufficient evidence claim. And again, it is our position that that is outside the scope of the ODI and also just improper for habeas development, period.
Reporter, she said ODI, in case you missed that. All right, we're approaching the point where we need to give everyone a break. Mr. Robbins, what do you say about 53?
That it is, say we would, one can offer it similarly before, not for the truth of the matter, sort of the key parts to sort of focus the court a little bit, I think would be on page 8, where it shows that Mr. Falk says, we were just trying to get away. We weren't trying to kill anybody. And on that same page, Mr. Martin is asking how Officer Canfield died. I think for one thing, the asking a question is not an assertion. There's no truth to the matter being asserted there. So it's not that piece of it is not hearsay. The Mr. Falk statement could be offered as a present state of mind, excited utterance, but also, like I was saying before, I think these also can be offered not for the truth of the matter asserted, but to show the state's awareness of issues with their case and that they repeatedly had no confessions, no statements. Instead, all the statements of the relevant parties indicated the Officer Canfield's death was an accident.
And so what is the relevance of that to our proceeding?
It's one more piece just showing that the reasons, I mean, we have asserted, right, that what they did at the second trial, their conduct interfered with Mr. Falk's right to counsel and to a fair, reliable proceedings. And that this helped show their motive and their state of mind at the time they got to the second trial, having had the first trial implode.
So in that sense, is it like 68, the juror's statement of his doubts about the state's case?
It is similar, yes.
Your Honor, I have a quick response.
Go ahead.
Again, Fox statements within that cannot be excited utterances. Those are spontaneous requirements. They have to be done in the course of whatever is happening. And he obviously had been taken into police custody at that point. He had every motive to fabricate or lie or dissemble or any reason that these are not proper hearsay exceptions.
There's no showing that there was any excitement here. So it would be a leap to have to infer that there was sufficient excitement to invoke the excited utterance exception.
Yes, Your Honor. And as to Mr. Martin's statement, where the argument is that he asked a question, it is still hearsay if we are deriving the truth of the belief asserted. Here, the belief that is being asserted is that he wasn't aware that Ms. Canfield died, or that he didn't intend to do it. That is what they're still trying to prove. That is what the question would go to show in their argument. As to the last argument, that this goes to the right or the interference with counsel, frankly, Your Honor, I think we can see the leaps and bounds that have to be made from any of this perceived motive to somehow then step in and ask him to waive counsel. It's difficult to follow because it's actually non-existent. But aside from that, I think it highlights, again, all they're doing is a retrial. All they're doing is putting on the evidence they wish someone had put on at trial. They wish John Falk had. They wish he hadn't pled guilty. They wish that he hadn't waived counsel. And had they would have been absolutely free to poke whatever holes in the state's case exist. That is the adversarial nature of the proceedings. To say that the state knew that it had a case to prove and knew that it had to rebut evidence, I'm not sure how that could possibly go to show any kind of motive here, particularly where, and this will be proved at the hearing, there's no evidence that there was any interaction at all between the state and John Falk before he ever first said he wanted to fire his attorneys. They could have put this case on at trial if John Falk hadn't pled. They could have poked whatever holes they wanted. They could have tried to call.
At this point, just arguing the weight of it, not the admissibility. This is all to the how it's being used.
Well, I'm making a relevance objection, Your Honor.
I will consider it. Let's take 10 minutes here. We'll resume at 10 after 11.
Thank you.
The court say 11:10?
Yes.
I said 11:10.
Okay, thank you.
Your Honor.
Okay, we are back in session after our break. Which exhibit do you want to take up next, Ms. Vindel?
Yes, Your Honor. The next exhibit is applicants 55. And this one should go quickly because it's essentially the state has hearsay and double hearsay objections. As to hearsay, it's the same argument as 40, 41, and 53. These are OIG investigator notes at the time of the offense. So again, they are obviously not public records and don't meet a business records affidavit exception either. As to double hearsay, the point of them, according to applicant's response, is Mr. Falk's statements to the OIG investigative officer, I believe, again, after he was in custody after the offense. So as per applicant's exhibit 53, these are the same issues with the hearsay within hearsay as to statements from Mr. Falk. Again, not excited utterance, not present sense impression, not mental state. So I won't repeat those arguments again unless the court would like to hear them, but just for the record, it's essentially all the same as the prior exhibits. In addition to relevance like 53. it's the same relevance argument as well.
So, Mr. Robbins, if you agree that the ruling on 40 and 41 and 53 really drives this one, we can move on. If you feel like there's something else needs to be added, I'll listen.
Just very briefly, I mean, I do agree. It's largely similar. I guess the one that maybe distinguishes 55 from what we just talked about 53 before is that this one is admissible as a business record being offered against the state. It's a police report being offered against the state pursuant to Jefferson. The internal statements of potential hearsay, again, are not for the truth of the matter, but to show the issues with the case. So it's largely similar, but this one has a business record affidavit that lets it get in through Jefferson.
Yes, Your Honor, that's factually true that it has the business records affidavit, and the state's same argument suggesting that the CCA in Cole v. State has determined otherwise would apply to this argument as well then, or to this exhibit.
Okay, what's next?
The next is 58. This is a firearms report from DPS. The arguments, well, I'd like to clarify one thing for the record. I believe this report was discussed on Friday, and there was some handwriting on it, and we were told by applicant that he would resubmit a clean copy that did not contain handwriting. And if that's the case, then again, we do not have an authentication objection to that document. If there is handwriting, we need that to be identified. So our understanding is that's been admitted as a clean copy. So I will not address authentication on that. As to hearsay, it is the same public record issue as 53, well, excuse me, 40, 41, 53, and 55. And the only added point that the state will argue here is that, again, in Cole v. State, they specifically addressed DPS reports, and they held that DPS labs are a uniquely litigious and prosecution-oriented environment, and that those items tested are unquestionably a product of evaluating results of that investigation. And as such, they are clearly not public records, or therefore any business records exceptions as well. That is the only argument specific to those that we have not raised before, I believe. Unless applicant wants to raise the present sense impression argument that he raised in his response.
All right, Mr. Robbins, what do you say?
Just one moment, Your Honor. I thought I had the exhibit open, but it disappeared. Right. So, and I guess just to make clear, I think we're offering it as is with the handwriting on it, which I'll get to that just to make that clear at the outset. So in terms of authentication, this was provided by the state to Mr. Falk's trial lawyers, first trial, or maybe even the second trial as well. We also obtained it separately from their files. This copy with the handwriting, my understanding, comes from the state's files. So the handwriting is a statement of a party opponent. The admissibility, again, is got a business record affidavit, so it's admissible as a business record by the defense against the state pursuant to Jefferson. Let me stop in this context to talk a little bit about why Cole should not be persuasive in this context. I mean,
Your Honor, just one quick note, there's no business records affidavit on the exhibit.
Oh, I'm sorry. All right, I misspoke. Thank you. We have submitted a subpoena for a business record affidavit for this. So we hope to get one before the close of proceedings. We expect to get one. The, but in regards to Cole in this context, of like this is what this is, Your Honor. This is the toolmark, the state's toolmark experts report with their conclusions, which they're trying to link, they're trying to use to link Mr. Falk to a rifle that they say shot the horse during the escape attempt. And this is related to, I think, one of our false testimony claims, but also goes to, also there is, as the court may remember, there is a problem with the chain of custody in this, in that when you put their records together, they cannot tie Mr. Falk to the gun that they want to. And that came out at the first trial, did not come out at the second trial. And so it shows, so that's just so you know what you're looking at. This is what the report from the toolmark expert that testified, I believe in both proceedings. So again, we submit it's going to have a business record affidavit and would then be admissible under Jefferson. Cole's reasoning is outdated. It's a 1990 case talking about forensic science, basically at the dawn of the DNA era. You know, before like DNA was barely being used regularly then. There has been a sea change since then in the way crime labs operate and things like that happen, including in Texas, the forensic. So, and so Cole is basically operating on the premise, this person is basically a law enforcement officer. That's why you shouldn't be allowed to get this. This is a law enforcement, and so it's not a public record and doesn't come in. But since Cole was decided, the Forensic Science Commission was created by Texas, which now licenses the analysts as opposed to law enforcement officers who are licensed by the Texas Commission on Law Enforcement. There's just been, I think Cole probably predates Crawford versus Washington, and the issues that were, you know, the Sixth Amendment concerns that were there. There just has been a lot of changes since Cole was decided about how we look at how the forensic science community deals with things. I mean, it was basically saying these people are just police officers with smocks, and so therefore their report shouldn't get in. I think that has changed significantly since that case was decided by, among other things, the legislature's creation of the Texas Forensic Science Commission. So I think for that reason, the court should, when it reads Cole, understand it's a very old case looking at a different context, different circumstances. So with that, in addition, it came from this handwriting belongs to the prosecution team. So the handwriting is a statement of a party opponent. I think, and then again, we are not really, the arguments can also be made, we are not offering it for the truth of the matter asserted, because what we're not trying to show to prove the state's case. This was offered at the state's case to link Mr. Falk to the gun. We're saying there was problems with that evidence that did not come out at the second trial that they were aware of. And so this shows, this is a piece of that evidence. And so it's not being offered for the truth of the matter asserted, but to show their awareness of the issues of linking. And so you can see the handwriting on the pages linking certain items to certain correctional officers, certain witnesses.
So let me interrupt a moment. Why does the statement of party opponent rule govern the admissibility of 58?
Well, statement of party opponent would be the handwriting on the side because it's handwriting by prosecutors.
Well, I'm referring to the entire exhibit.
Okay. Why does it or does it not?
I directed the question to Actually, Ms. Vindell, should have been more clear.
I apologize.
Isn't this admissible as a statement of a party opponent?
A DPS officer is a party opponent. A DPS officer is not a representative of the state in a prosecution against a particular defendant, and that is what party opponent must be. He has to be, that's why the prosecutor's statements get in. That wouldn't be why the DPS statement gets in.
Well, the party is the state of Texas, and a DPS trooper is the state of Texas employee.
Your Honor, if you'll give me 1 second to look at the rule.
I'll do the same. What is the rule?
I
Number.
believe it's 801E, Your Honor. Your Honor, frankly, it's difficult to argue because it just doesn't seem to fit. A DPS is a separate state agency from the prosecuting agency who is the party in a prosecution. While they are state employees, I mean, I guess I'm just not sure where this would end then. Is every state employee in any capacity a party opponent whose statement can get made or admitted for its truth into any proceeding? Or excuse me, I believe this is not hearsay, so it would not be for its truth. But the DPS was asked to analyze something in a prosecution doesn't mean that they are making statements admissible in a later habeas proceeding. The argument was only raised, notably, Your Honor, as to the handwriting on the report, not to the entirety of the report. Again, I'm confused on the handwriting argument because I believe they agreed on Friday to submit it without handwriting. So if we are going to claim this as party opponent, even in the handwriting, then we do need authentication. I'm not sure whose handwriting that is. I don't know that it's a prosecutor. I don't know that it's not Mr. Tim Kuntz or Counts. I'm not sure how to pronounce his name. I don't know who wrote that at what point in any of the proceedings. And so they would need to show that. But if what they're just getting in is the record, which is part of the state's file, then we wouldn't have an authentication problem, which is why I was going to withdraw that objection if there was no handwriting. However, again, this is clearly law enforcement. And Your Honor, by that logic, there would be no point of the public record exception keeping out law enforcement statements. There would be no point of Cole v. State holding that they can't come in under business records exceptions. They were very free to consider that maybe this comes in because the DPS analyst in Cole v. State is a party opponent. And they didn't address that because it's not how it would work. In particular, our applicant's argument that Cole v. State is just outdated is not an argument that it's not precedent. Cole v. State actually reaffirmed its hearing on, or reaffirmed its original opinion on rehearing, which was moved for by the state. And in its rehearing motion, it did argue that maybe later case law or other cases in other jurisdictions undermined its prior holding. While it's still a 1990 rehearing opinion, it had specifically addressed the argument that it has been made outdated by other jurisdictions or other cases. And the CCA reaffirmed its prior opinion and actually added further clarification that continued to say, this is not 8068 and this is not 8066, or excuse me, 8038 and 8036. Finally, as to the argument that it's not offered for its truth, that's flatly belied by the argument of what's been raised. This is a false testimony claim. There are two components to a false testimony claim. If they are only showing, well, there are three, but two at issue here. If they are only showing that the state had knowledge, and therefore this was a knowing use of false testimony claim, they do not need its truth, which means that we could admit it with that limiting instruction. If they are using it to show that something in this document makes testimony actually false, that only matters if it's true. It's clearly offered for its truth. You must show that that testimony was factually false, not that it was impeachable, not that it was or should have been limited. It has to be false. That is how you prove false testimony. So if it truly depends on the reason they're using it. They're using it to show falsity, which is the point of their claim. Their claim is that Mr. Kuntz testified falsely that the gun could be linked, or the bullet in the horse could be linked to the gun that Mr. Falk used when he shot at Ms. Canfield. That's the claim that they're saying is false. They're using documents and a DPS report to say that it is false. We have to assume that what they're saying is the DPS report is more true than what Mr. Counts testified to. This is clearly hearsay.
So let's get some clarification. Is the applicant offering the exhibit in its form that it appears in number 58 that's been shared among us, that includes the pen and ink entries, or not?
Well, if we can, yes, I guess our fallback would be if the court will not permit those as a part of the handwriting as part of the opponent's statements, our fallback would be no. And I can address sort of more substantive things about that. And reply to some of the other things that counsel for the state said.
So how did this document get to the applicant? Was it produced by the state?
Yes, Your Honor. I mean, it is my understanding that this is discovery from their case that has come, I've probably been produced by the state 3 times, to the first set of trial lawyers, to the second set of trial lawyers, and to us. I believe the court's reading of 801 D2, no, E2 is correct. I mean, it does, if you look at the rule, those are A, B, C, D, and E are all alternatives. They are all ors. And so the one that fits this pretty well, snugly, is C, 2C. This is a statement offered against an opposing party and was made by a person who the party authorized to make a statement on the subject. They commissioned, the prosecution went to DPS and said, get us a, make statements about this evidence for us. So their framing in terms of like the claim, just so it's a little bit clearer, the claim is not that necessarily the conclusions in this report were false, that the tool mark conclusions from one weapon that this report sets out, the casings from this appear to be coming from this weapon. That's not the piece, I don't believe, of the testimony, and I'm not the most familiar one on the team. Mr. Fuller's more familiar with it, so I hope I'm not messing things up. But it's not that the tool mark conclusion, we have not brought and submitted a tool mark examiner to say he's wrong, this gun and this casing may not match. That's not what we're doing. It's the who had the weapon, who was holding the weapon piece. So I just don't want to make sure that like the court's clear on that this is one piece of the chain of their evidence. And I believe it fits both as a statement of party opponent, and it shows it fits as not truth of the matter asserted because we're showing what they believed.
Your Honor, if I may respond.
Very briefly, we need to cover some ground.
Yes, Your Honor. The problem is I don't know exactly when this was produced. If they're willing to show me somewhere in the state's file that this exact document with allegedly prosecutor handwriting was provided to them, then I might be willing to deal with the authentication issue. But and also they can ask the prosecutors on the stand to identify if this is any of their handwriting. But I'm confused how we're assuming so much to prove so much. They're proving that the state knew this or the state didn't know that by relying on handwriting who we don't know who it belongs to. Also, as to the last point, that is not a correct characterization of the claims. There are two claims with regard to Mr. Kuntz. One is challenging his ultimate conclusion that basically whether he's capable of ever making a tool mark analysis. And the other is also challenging the truth of the chain of custody. So either part is still going to directly challenge the truth of the assertions in here as testified to at the trial. They're either saying that Mr. Kuntz was incorrect when he identified the gun to the particular person, or they are saying he was incorrect for various reasons, I guess, because of later developments, when he even tried to identify the gun and the bullet belonging to the same thing at all. So there are two different claims being raised here.
I believe my understanding, if just to adjust a little bit, that in terms of challenging the truth of his specific tool mark analysis, I believe there's a part in there saying that he overstated the certainty of his exact match.
Okay, let's move on. What's the next exhibit the state wants me to reconsider?
And just to be clear, Your Honor's holding that ruling then?
Yes.
Okay. Like, just give me a second. I've spread out my notes. I'm missing one. Okay. The next exhibit is 59. It is the weapon sign out sheet from TDCJ, which purports to make statements about which officer possessed which gun on the day of the offense. Excuse me, we have the same problem on authentication on this one as exhibit 43. It's a business record by an OAG investigator or OAG custodian of records. They are not the people who are signing guns to TDCJ officers on the days that they go out to the field force, so they cannot talk about whether this document was kept in the regular course of business, whether they can verify the manner of creation, whether they can say the documents were created at or near the time they were created. And they can't say that it was created by someone with knowledge. The only thing OIG can say is that it was part of their investigative file. They argue in their response that it is authenticated under Rule 901 because there was testimony at the first trial that admitted it by, I don't actually recall who it was. I believe it was Casey Allen. I might be wrong about that. But first of all, the state objected to its admission at the first trial, precisely for some of the reasons that relate to the prior exhibit. There's two kinds of handwriting on it. We don't know who wrote what. And if you're being offered for the truth, the state objected to that. So to rely on that testimony only goes to highlight the difficulties, period, of relying on testimony from a former trial, which we will get into the judicial notice issue later. So I won't address that now, but prior testimony is hearsay and it cannot be used for its truth and it cannot be used to lay the predicate for any evidence. As to the, let's see, hearsay argument, this is the same one as 40, 41, 53, 55, and 58. Because it's an improper business records affidavit, we don't even meet the first level of hearsay. Again, Officer McCurdy, whose name appears at the top, to the extent he's the person who wrote everything on that log, which is not clear from the face of it, he has no duty to report to OIG. And The present sense exception that's argued in the response, it doesn't make any sense in this context. Who's the declarant? Is it Officer McCurdy? Is it the officers who sign out on the sign out log? What event are they describing? It doesn't meet the face of the rule. And then their final argument is that somehow employees in an employee context signing their name next to a document have an interest in property that would meet the exception under 803.15. And that's frankly absurd. They cite to Madden v. State. The case for that is 799 SW2D 638. It's in their response. That case was a list of weapons and corresponding serial numbers that were owned by a victim of a capital murderer who then took those guns and sold them. So that statement was offered for the truth of showing that the guns did in fact belong to the victim, and therefore the defendant possessed those guns when he sold them. There's absolutely no support for saying that an employee who's checking out a gun for the day in the course of his duties has any legal proprietary interest in that gun. And finally, as with some of these others, it depends on why they're offering it. If it's for a non-hearsay purpose, meaning that they're not offering it for any truth of the statements within, the state has no objection subject to a limiting instruction, but that is not what they're using it for. So if that's the case, then we object on hearsay.
So why is this not a statement of an opposing party?
Your Honor, when the TDCJ officers were checking out their gun, they were not a party. They were just doing their normal course of business. They were doing their duty on that day. Nothing that was stated in that was made with anticipation of litigation at all. The state
I don't see that the rule requires anticipation of litigation.
Well, but it does require them to be an agent of the state or an agent of the party, or as applicant argued earlier,
employee.
TDCJ is a different entity from Walker County District Attorney. Those are the parties in that proceeding. How can, Your Honor, frankly, I guess I'm not sure how to respond. I guess then every state agent is a party opponent. Even when they're doing duties that have nothing to do before an offense is committed. Mr. Falk hadn't escaped yet.
I'll give you all some time to look that up. But it seems to me that answers the admissibility of this exhibit and many of the others.
To clarify Your Honor's question on this one, the question is whether a state employee acting in his regular course of business before an offense has ever been committed is a party opponent. That's the question we're researching on this one.
The question you're researching on this one is whether this particular exhibit is admissible under the opposing party statement rule. And you can argue why it's not. But I don't want to frame the question in terms of the limitations you proposed.
May I add something slightly that I haven't said before? Or should we just
if you want to stay here till midnight, you certainly may.
I do not want to stay here till midnight. But if the court is basically, if what I'm saying, the court is admitting it, then I will definitely not say anything more.
Okay, you are ahead in the score
at
the moment.
Let me quickly just add, that basically what's going on with a number of these exhibits with the gun is sort of, unjust, unfair. Basically, the state is trying to hide its own evidence that it offered in the capital trial against Mr. Falk. It is trying to run from its own evidence. It is trying so hard. It is parsing this, trying to raise authentication issues about a record that it knows is authentic. And so Chambers versus Mississippi and cases like that from the Supreme Court tell courts not to mechanistically apply the hearsay rules to defeat the ends of justice. And that is specifically what they are trying to do. This is their own evidence. There's no hearsay reliability issue about it. This is just obstruction, gamesmanship. And the Supreme Court has repeatedly said in cases like Chambers versus Mississippi, Sears versus Upton, that courts should be wary of that and not apply the hearsay rules rigidly in that kind of manner. I'd also submit the Madden case is good. This is a list of weapons that shows state property being loaned out and keeping track of it. And so therefore it is a handwritten list affecting an interest of property, even though it's not legally executed like a mortgage, which is it's very similar. It's showing where the state property is being passed out.
Okay, we're going to move on now.
Your Honor, I would just request a very quick response to that last charge.
No.
Okay.
This is not my first rodeo. I'm not driven by charges of the state trying to obfuscate or the defendant trying to obfuscate. I'm here to apply the rules of evidence, not the motives for invoking the rules of evidence. All right, what's the next objection?
The next is applicant's exhibit 61. Your Honor, the purpose on this authentication objection is clear. We have reason to believe it had nothing to do with any of the prosecutors in this case. I believe it was Mr. Martin's case, and that is we've asked them and no prosecutor was able to identify them. So I don't know whose notes these are. Again, if they're just offering it for the purpose of saying it came from the state's file, we are not disputing that. I'm not sure which part of the state's file. I don't know if it was this case or a completely different proceeding, but it's a state's file. And again, obviously we're going to research this question now, but if they can't prove its authenticity, that this belongs to a prosecutor in this case, we believe it's hearsay because there's not a party opponent, a prosecutor in a different case, and we wouldn't believe is a party opponent in this case. Frankly, as well, this is not a statement against interest. A prosecutor noting that there's something it needs to investigate further doesn't fit within the hearsay exception, which specifically is limited to pecuniary and proprietary interests. And that has nothing to do with what he's talking about there. It's not a mental condition. They're not offering it to say that this was the plan, that the state intended to look into this further. In fact, it seems to be saying, they seem to be suggesting the opposite, that the state buried its head in the sand about any possible weaknesses in its case and just chose to railroad the defendant instead, I suppose. And again, if they can prove it's a prosecutor in the case and kind of generally, we're not hiding anything. We're saying there's a proper way to put this evidence in front of the court, and they could have called these witnesses. They could have asked them these questions, but they're trying to have a paper hearing. And so if they would like to ask a prosecutor, one of the prosecutors, if they've seen the document before, if they know whose handwriting it is, perhaps one of them will say they do. And that would be the proper way to get all of this in and ask questions about them. Same goes for all of the other documents. They're free to ask questions about it. They were free to call Mr. Kuntz if they want to impugn him, but they haven't done so. And that doesn't mean that these documents are therefore admissible. So that we object on authentication and hearsay grounds on 61.
So was this produced in discovery?
My understanding is that we obtained it when we went to their office. So in post-conviction, when we went to their office to review their file from Mr. Falk's case.
State?
Your Honor, I have not seen that document when I looked through the state's files that was publicly available. So I'm not sure, but I was not the prosecutor at the time. So I'm not disputing that it wasn't in the state's file. I'm agreeing to that. It probably was. It's clearly work product, which has typically been withheld. So I do not know the circumstances in which it was provided. And again, as a matter of courtesy, the state gave, my understanding is access to both the Martin and the Falk trial.
Excuse me.
Is everything okay, Your Honor? Shall I proceed or?
Yes, we're fine. So I think that takes care of the authentication issue. As far as the hearsay objection, isn't that answered by statement of party opponent again?
It would depend on what the research shows, Your Honor.
All right, let's move on, please.
Okay, next is applicant's exhibit 62. We have no objection to page 1. Everything else is the same reason as 59. Unless again, all they're using it to offer is to show that Mr. Weeks had the document and knew of the document, then it could be admitted with a limiting instruction. This can be resolved if they're admitting that it's just approved knowledge, but the more they want the truth of the underlying documents, that's where these hearsay exceptions come in.
Did you say you object to page 1?
I have no objection to page 1, Your Honor.
No objection to page 1. Okay. Well, it appears to me that this is just one more example of a statement of a party opponent.
Perhaps, well, yes, Your Honor, that's why we don't have an objection to page 1, but page 2 is not written by the DA's office, so it is possibly the same research issue.
It is the same research issue. It appears on its face to be a record from something described as an armory.
It is the same exhibit contained in applicant's exhibit 59, which is why our objections to those particular documents are exactly the same. But if the purpose of this exhibit as distinct from 59, otherwise these are just duplicates, is just to say that that Mr. Weeks had knowledge of him sending that fax, then we would not have an objection to its admission subject to that limited purpose.
Well, I'm not going to require any limitation on the purpose. What next?
We only have 2 left, Your Honor. Next is applicant's exhibit 64. There's an authentication objection to this. These are personnel files from a separate state agency going to an officer. There's no business records affidavit. There's no indication there's a public record. In fact, there's no evidence at all about how it was obtained. I believe in applicant's answer, he specifically said he obtained it directly from TDCJ in post-conviction investigation. So I think, again, it depends on for what purpose it's being offered. And in this case, it's for a Brady claim. So they must authenticate that these documents were somehow possessed by or available or within the knowledge of the state. Further, this is hearsay and double hearsay. He says in his response that it is only used to show bias of the officer who testified by insinuating that he has lied in other instances. This means that it is impeachment evidence that may have been used at trial, but if it's impeachment, what is the bias? If it is a general character of untruthfulness, that would be admissible, but it's not because they're offering specific instances of conduct. They're implying that he lied on other occasions and therefore shouldn't be trusted on this. And that is impermissible under Rule 608B, as well as under ex parte crimes by the CCA. Offense reports and witness affidavits would not be admissible to show a state's witness capacity for truthfulness or untruthfulness. There's a way to do this, and it's not by showing other instances of misconduct to undermine a particular witness's statements.
All right, what do you have to say, Council?
I'll
Mr. Robbins?
try to be as quick as possible. I guess as to authentication, it was obtained through the Public Information Act, therefore also public records exception. It was not produced as part of a law enforcement investigation, so it fits in that. As far as also in authentication, I believe our office served a subpoena for it to be authenticated with a business record affidavit. And Ms. Vindel's, we did not get one because Ms. Vindel's office, the Attorney General's office, acting as TDCJ's counsel, quashed the subpoena because at that time there was no date for a hearing. But it doesn't seem like there's really any question about its authenticity. They didn't, I don't think. So it comes in as hearsay, I mean, it's not as a public record. It's also not for the truth, not necessarily, I mean, its relevance was both as it's to a Brady claim to impeach and offer, not necessarily impeach, but to be cross-examined. An officer who testified that he heard Mr. Falk make derogatory statements about Officer Canfield. These show that he was disciplined for falsification of records or making a false statement 2 prior times, as well as a third separate discipline for improper conduct towards a subordinate. And so it shows one, impeachment of false statements. It also could have been shown for bias to show that this was an officer at TDCJ who had a motive to curry favor with TDCJ because he had a disciplinary history that put him in not good standing. And he was making up a story about one of the people TDCJ most disliked, meaning Mr. Falk and his co-defendant. So to that extent, it could have been used. And to the extent that whether or not it's the underlying true that he made false statements or falsified records before, that doesn't matter for the truth of the matter for the bias purposes, because to the extent that he knew he had been disciplined for this conduct, he still had the motive, whether or not he actually had made the false statements in the past.
All right, I'll think about it. What next?
The last one is applicant's exhibit 96. As with some of these other documents, we will stipulate that the underlying document came from the state's file and that the state created it. So page 1 is unnecessary, and we would withdraw the objections to that page if it was removed. Notably, Your Honor, we objected to the release of what is clearly state work product in pre-writ discovery. So this was only given under court order and not because it was otherwise available to the opposing party. So it does need to be authenticated for its purpose. And again, authentication is tied to what they're purporting it to be. It is not that it just appears to be a separate document on its face. They are purporting that this is the list that was given by the state to Mr. Falk at trial for the purpose of manipulating him into excusing a bunch of jurors who, I guess by their argument, were not otherwise excusable. This was an excusal by agreement process, and they're saying that this was the list and this is evidence of that list. We have reason to doubt that because, as noted in the state's answer in March 2021, one juror on that list was in fact not excused by agreement and was called to question and called to testify. If they can get Ms. Starnes or Ms. Stroud or whatever prosecutor to say there's nothing on the face of the document that indicates it was given to anybody. It is clearly prosecutor work product that we were required to turn over by court order. And there's nothing on the face saying when it was prepared, when it was given to Mr. Falk, who prepared it, much less that this was the one that Falk agreed to, I guess, because he was manipulated by the state into doing so. They can ask the prosecutors that on the stand. They can also ask Mr. Falk. Mr. Falk can authenticate whether this was the document he was given and that he agreed to excuse. As a result, we don't believe that the predicate has been laid yet for this exhibit. We don't believe it was the exhibit that was given to him. And so those are our objections to that exhibit, Your Honor.
Well, Ms. Bendel, your letter says, enclosed is the typed list of prospective venire members that were excused by agreement between the state and Mr. Falk at his 2017 trial.
Yes, Your Honor, there is evidence on the record that there were many of those jurors were excused by agreement in Mr. Falk's trial. And that list accurately reflects what the record reflects, except for one juror on the list. Their allegation is not just that there existed jurors that were excused by agreement, is that they typed a list in order to confuse and manipulate and overbear Mr. Falk when he was pro se, that they had some document that they gave him with the intent of manipulating him into that outcome. This document does not appear to be that document.
Well, I suppose that goes to the weight as opposed to the admissibility. I'm prepared to rule on this one, and the ruling remains the same. 96 is admitted. Okay, so where shall we turn next? Is it the judicial notice conundrum?
Your Honor, yeah, I think that would be a good, makes the most sense to go now to that.
So let me get the rule in front of me that drives judicial notice. There's an entire article in the rules of evidence inclusive of rules 201 through 204. I think 201 is the applicable rule here. All right, so one by one, what is the applicant asking this court to judicially notice?
Okay, so you want the full list of things, not just what's in dispute, correct?
The first one that's in dispute, please.
Okay, so the one that's in dispute, I understand, is the reporter's record, and I don't possibly the clerk's record from the first trial in Mr. Falk's case, which was styled case number 24083, which occurred in this court, in the 278 District Court.
Sitting in Brazos County.
Yes.
All right, go ahead.
So, right, we're not asking the court to take judicial notice of proceedings that some other court presided over. We're asking the court to take notice of its own proceedings. And we're not asking the court to use the transcript from the mistrial to try to ascertain the truth of what happened during Mr. Falk's escape attempt, or to make credibility findings based on that transcript alone. What we're asking the court to acknowledge is that the reporter's record from the first trial is a substantially accurate record of what the witnesses, the lawyers, and the judge said in those proceedings. And we're also asking the court to recognize that the reporter's record is the record the state had of the first trial, similar to sort of non-hearsay to show the effect on the listener. This is their record of what they had. And so in response, they did what they did at the second trial. I think it's important to remember a few pieces of background. We tried to get our own transcript of the first trial that presumably would have been certified, but the court declined to authorize funding. Once we got the transcript from the state, we didn't need to pursue that option anymore. Because we didn't have any other source of knowing what the first trial was. Because as I said before, my understanding is none of the defense lawyers had this transcript, only the state did. So it's before my time, but I believe that when our office obtained it from the state, we didn't focus on the lack of certification because, to my knowledge, we've never had prosecutors do what they're asking this court to do. We've never had prosecutors to try to keep a court looking at a transcript of its own proceedings. And what's I think is odd about this is not only any transcript, it's their own transcript they're objecting to. They ordered it, they paid significant money for it back in 2013, which you see from, that's the date of it from their, and then they used it to prepare for the retrial in 2017. And now they seem to be trying to claim it's not sufficiently authentic. I don't know if they're talking about, if they're talking about the, I mean, obviously it contains the sworn testimony they presented in a death penalty case. So I presume they're not trying to say that that part of it is unreliable. But I also, from a practical matter, I wonder what it is that the state believes should happen in this situation. We should reconstruct the trial by calling all the witnesses back to the stand in this post-conviction proceeding and asking them if the transcript seems like it contains what they said before? Or do they think the trial testimony should just be wiped from the face of the earth and not like it never happened before, and that no court can know what happened at that first trial? I think both of those don't make sense. This does not feel like a record that the hearsay rules were designed to keep out. And so I would ask the court, for those reasons, I think the court should do it. I also think it is important to understand that no matter how many times they will try to reframe what we're doing, this is important to the presentation of Mr. Falk's claims, to our evidence, because the transcript of the first trial provides necessary context so the court can understand what happened at the 27 trial. the prosecutor's conduct that's at issue didn't happen in a vacuum. And so I think I've explained before sort of what I mean, that the misconduct that occurred in 2017 was in some ways a response to things that had happened in the first trial. I think it also helps demonstrate, so besides demonstrating the motives, it helps demonstrate the prejudice, because there was no adversarial process at Mr. Falk's retrial in 2017. The transcript from the mistrial helps show what aspects of the case looked like when there was adversarial testing of the state's case. And that contrast also helps show, it also shows ways that they've overreached, because I think we specifically reference ways that they changed the testimony or things that they did or were not allowed to do, and especially the medical examiner's testimony about the injury resulting from a certain speed of the collision, which they were not allowed to present at the first time, but they did at the retrial. It's all necessary context that is important and necessary for Mr. Falk to present his case and have his full and fair opportunity to do so. As I mentioned before, I think if the court isn't willing to take notice of the uncertified transcript, we either need a continuance in the funding to obtain a certified copy, or we need the funding to obtain a certified copy and at least make sure it's available to us before we submit proposed findings of fact, so we have enough time to review it and rely on it. I think which remedy depends on the state's case. I mean, the state's position. Like if every time we reference something in the first trial, they're going to be like objecting, and that's not what was said. We don't know what was said at the first trial. I think that would be unworkable, and I think we would need the continuance. I don't think the court needs the certified copy, because this is the copy they have had, that they paid for, and they have had in their files for, they had it for 4 years to prepare for the retrial. And they never see, it's prepared by the court reporter looking at his materials. It wouldn't have served them any purpose if they had any doubts about, if they had real doubts about its authenticity and its content. It wouldn't have served any purpose. They wouldn't have paid for it. So I don't think the court needs the certification to take the judicial notice. And then I'll just add, I think this is a situation that the Supreme Court cases where they say that the hearsay rule shouldn't be applied mechanistically applies to situations like this. So again, submit this is not the kind of document hearsay rules were designed to keep out.
All right, Ms. Bindel.
Your Honor, applicant's last point is literally incorrect. That's precisely the point of 804. It is limiting the use of former testimony by a witness to unavailable witnesses. If the hearsay rules are not designed to keep them out, there'd be no purpose of that rule. But going to the general argument of judicial notice, we're very in the weeds on evidentiary rules, when if you look at the plain text of 201, this just does not fit. A court may take judicial notice of any fact, and it is only a fact that is, quote, not subject to reasonable dispute. That's 201B. We have said in our email, and we will say again, we have no objection to the mere fact that prior proceedings occurred, any number of the facts. We have no objection to the fact that there were several proceedings and a trial on the merits in 2012. We have no objection to the court taking judicial notice of the fact of mandamus proceedings in both the CCA and the 10th Court, nor do we have an objection to the fact that a trial occurred in Jerry Martin's case. They clearly want more than that if they need certification, because that should be enough. If the only point is that there was another trial, then that is all that is actually necessary. We don't need them transcribed. We don't need them certified. We don't need anything underlying that. But fact of the matter is they want more than that. To be more specific, a court may take judicial notice of records in the same court, in the same or an ancillary case, but one court may not judicially notice the records of another that involves the same case and same parties, unless the necessary information concerning those records is supplied. There are plenty of cases that go to that, and in particular, one issue is a different judge may not take judicial notice of evidence introduced in a prior proceeding that he was not part of. That comes directly from the CCA.
Citation?
Harris v. State, 738 SW2D 207, pin site 219, note 10, and also 219, but it's explained further in note 10. In that case, judicial notice was not proper where the instant trial occurred after the reversal of a first conviction, and the trial judges were not the same. The court cannot take judicial notice by the testimony heard before him on another trial and enter judgment thereon. And in fact, this is sort of the practical problem with applicants' argument. Any retrial, what would be the point? We would always just offer all of the prior testimony for any subsequent retrial. That's not how this works. If you can just judicially notice it, and now all these witnesses' testimony is before the court, there would be no retrial. You would just do all of it on paper with the witness's prior testimony, which again is limited by Rule 804 of the Rules of Evidence. Further, when the court takes judicial notice, it's appropriate to take notice of certain documents being part of the record. It's appropriate to take judicial notice that a particular record was filed on a certain date, or that information was before the court at a particular hearing, or that hearing contained certain information, but you cannot judicially notice the truth of their contents. The truth of testimony is subject to reasonable dispute, which is precisely what Rule 201 says is not permissible and is actually evidenced by Mr. Falk's own claims. He is arguing that the testimony is false. He is arguing that the testimony from the 2012 trial may be better, may be more accurate, may be more truthful of what occurred. This is the dispute in this case. Who is right? When did they say it? And when did they testify correctly? A court cannot judicially notice either as substantive evidence or as a predicate for admission. And again, it bears repeating, former testimony is already subject to the requirements of 804B1. Here, Your Honor is a different judge in a different proceeding. And especially if we're talking about Jerry Martin's case, that's an entirely different proceeding. The CCA has already decided the issue as it applies to even the prior proceeding when it said this isn't part of the appellate record. And again, it was applicant who specifically moved to include the 2012 documents into the CCA for the appellate record, to which they refused. There's no certified copy of the clerk's record created for appeal, and applicant is using the terms clerk's record and reporter's record very loosely. Those have specific meaning. They are appellate certified records for appeal. There was never an appeal, so what we have is a clerk's file, and what we have are transcripts. We do not have an official reporter's record. Moreover, the state possesses no certified copies, and OCFW concedes that they were denied transcription. So again, there is no official document here. As to the argument that they possessed no copies at all of the transcript, that is incorrect, or at least should have been, because one volume was certified, and that's volume 9, and that's the motion of the directed verdict that was filed in the clerk's record. So that should be within their files. Moreover, the CCA noted in the mandamus proceedings that there were certified copies of specific witnesses' testimony, though not entire volumes, and that is for Jeffcoat and Grissom. They were both available as of January 16th, 2013, as noted by the CCA in its In Restate Ex Relator Weeks case. So to those particular copies, the state has no objection to the court judicially noticing that a certified copy of the directed verdict motion was filed, nor does it have an objection to certified copies of particular witnesses' testimony being filed. But if they're going beyond that at all, if they are getting into the content of those witnesses' testimony and using them for impeachment or their truth or any other purpose in this proceeding, then they need to lay a proper predicate. Former testimony requires them to put a witness on the stand or requires them to show the witnesses are unavailable. And in particular, again, we have 21 different issues of fact related to false testimony that is predicated almost entirely on picking and choosing and cherry picking between the two different trial proceedings. That is the purpose they want these records in. That is why they are threatening the court with needing a continuance at this late juncture. And to that point, that argument borders on abusive at this stage. The state filed its answer 2 years ago, and in that answer, it noted difficulties with the different portions of the record that were available. It noted, in particular, that the appellate record and the CCA had denied to include the records on appeal. And it also noted that applicant had not then, 2 years ago, provided sufficient detail to judicially notice the records, nor had they attached any certified copies. The idea that 2 days before the hearing, they didn't know that they should do something the state pointed out in a public filing on March 16th, 2021 is absurd. And in any event, there's clearly inappropriate to, they want to be very specific on what they're seeking judicial notice of. We may not have objections. We've already stated repeatedly that there are facts that we are okay with judicial notice. But if they want the content, that's not appropriate.
Okay, final word, Mr. Robbins.
Yes, Your Honor. I mean, it's important to bear in mind that part of why we're here that would make it manifestly unfair to say we can't proceed with this transcript is we sought and did not and tried to get our own copy. And you can see from the order, the judge said that we have performed our duties and are commended by the court for their aggressive and professional representation. I think it's because my understanding is I think we filed a motion, didn't get an answer for a long time, filed a second motion trying to seek a ruling. But for us, the court to one hand deny us the evidence, that the record that we need, and tell us we have no need for it, when we are sitting here saying and explaining why we have need for it, I think that'd be manifestly unfair. Their references to the appellate and whatever the CCA said about developing the record for the appellate is very misplaced. I mean, obviously the direct appeal lawyers were focusing on matters that are just obvious from the four corners of the transcript from Mr. Falk's 2017 thing. It is clear why the CCA would say that those lawyers did not need to have the mistrial previous, because those lawyers in the direct appeal were confined to the transcript they had from 2017. But we are, by statute, required to go beyond the four corners of the transcript of the trial that we are seeking. We are required to bring evidence that is outside the four corners of the trial whose judgment we're challenging. And this is part of that evidence. So their references to what the CCA said about the appeal are in the wrong context and don't apply here. I think when they talk about some portions being certified, I think that is just distraction. I mean, yes, it is true that during the mandamus proceedings, the state got specific portions certified of the testimony they wanted. It's very limited, I think, to a couple witnesses. I don't know how many, but it's not many. It said is so that is neither here nor there. We sought our own copy of the whole thing, and that is what we need. Again, we're not asking the court to say that accepting that what was testified is like actually true, so much as that this was what the state offered before, and this was what was said. And I don't believe that it really is subject to reasonable dispute that this transcript that was prepared of proceedings in front of this court, prepared by the court reporter for the prosecution, is a reasonably reliable record of that.
Your Honor, may I respond?
And just I want to continue. I don't believe that, you know, whatever they're referring to in their state's answer was like somehow like telling us that they were saying that the court cannot take notice of its own trial. I mean, like I said before, we're here because we've never had this happen before, where the prosecutors were saying, we're not going to look at the previous trial.
Isn't part of the problem here that you're asking this court to take judicial notice of the entire transcript of the trial? And what you really want to do is to compare testimony from trial 1 to trial 2. Why shouldn't you be required to observe the rules of evidence? Like calling a witness and confronting him with his prior inconsistent statement.
I don't think we would, in this case, I don't think we would be doing that for the most part. We'd be saying, this is what you said, isn't it? It's a huge waste of judicial resources. And it's not just the witnesses, it's also what the judge and the lawyers said. And that there needs to be a record of those. Those are important.
Well, perhaps you need to direct me to a case where such a thing was ruled permissible. Because on the face of the rules of evidence, I am not yet convinced that I can simply take judicial notice of the entire contents of a trial, previous proceeding. So, assuming that I do take notice, does that mean it's admitted as an exhibit? How is that before any reviewing court later?
Yes, I think we could and would enter it. There's two possibilities. I mean, I think, yeah, but I think the easiest one is yes, to enter it as an exhibit. But the second one that we're asking for is we can go get a certified copy and it'll be part of the clerk's record or the reporter's record that gets sent up at the end of this proceedings as a matter of course.
Your Honor, I think this just highlights why this makes no sense. You can't just add in another court's proceedings and call it part of this clerk's record or this reporter's record. You also cannot backdoor this by offering them as exhibits because prior testimony is hearsay under the rules of evidence.
Well, for now, I am unpersuaded that it's permissible for me to take judicial notice of the entire first court's proceeding. And while we're at it, we all know that a capital murder reporter's record includes at least half of that record includes the voir dire examination. So what portion of the previous trial record are you asking me to notice?
I don't believe the voir dire has ever been transcribed. I think my understanding is it's just the guilt innocence phase, or as far as when they closed guilt innocence and never got to closing arguments. So I believe the portion that exists is the guilt innocence phase. There may be some pretrial. I'm not sufficiently familiar to be sure.
Okay.
That's
Well,
correct.
again, for now, I'm not yet persuaded that this is something that I can simply take judicial notice of for many of the reasons that the state's articulated here. So I'm subject to being persuaded later. There's not going to be a continuance while you go and get your own transcription. For one thing, that wouldn't cure any of the problems. And for another, you've had ample time to do that if you thought it was necessary, or to get a ruling on this judicial notice issue.
So is your honor's position that even if it was certified, the court couldn't take judicial notice of it?
I fail to see how that makes any difference. Would you care to explain how that would make a difference? Which objection that the state, which objection that the state has levied would be overcome by having a certified copy?
I believe that the fact that this is what was said at those proceedings could not, their accuracy couldn't reasonably be questioned based on the fact that the court reporter who was present recorded it, took notes, and said and certified saying that this is an accurate reflection of what happened in the courtroom in this court. I think the law is clear, and maybe we need to do more research that courts do take judicial notice of transcripts. I think there is case law on that. That is definitely, I think, something that has happened. It's happened in my own experience. I mean, but I understand the court's not persuaded by that, but there are cases where the courts say we will take judicial notice of transcripts that are, can be admitted into evidence. And so
that doesn't dispose of the problem of the time to acquire such a document. We're not going to take time to do that. Now, it may be that you can acquire a quote certified copy from the reporter in question, but I'm not going to delay the completion of the evidentiary hearing for a retranscription and new certification. So the dilemma for you, Mr. Robbins, is to convince me that I should and can take judicial notice of this entire guilt innocence proceeding in the 2012 trial. I'm unpersuaded so far.
Even if, what about portions where they're not for the truth of the matter asserted, like similar to the juror's affidavit, So for instance, at the end of the proceeding, the judge grants Judge McAdams, correct, who I believe is deceased and no longer available. Was it Keeling? I apologize. There's been a few judges on the proceedings. Keeling, basically explains that, like the juror, doesn't believe the case proved its case. And so those would not be necessarily for the truth of the matter asserted, but to show that the judge even told them, not just a juror, but the judge told them, your case is not working. And so it's the effect of the listener.
I'll consider that when it's presented to me.
And
Okay, what next?
I believe the last, let me check, before I say that, the next thing I think, and I'll double check, but I believe the last thing would be to ask you to hear briefly from Mr. Campos regarding a request to reconsider your ruling in regard to our expert reports that we proffered as exhibits, and that will not take very long.
Good. Good afternoon, Mr. Campos.
Good afternoon, Your Honor.
Where are you located, sir?
I am in Connecticut today.
You said Connecticut?
Yes, sir.
All right, sir, I'll hear you out.
Thank you, Your Honor. I'll be brief. Applicant submits that his expert reports should be admitted in this case for 5 reasons. First, admissibility of the expert reports would not be granted at the expense of the state's ability to cross-examine the testifying experts who authored the fulfilling the purpose of the hearsay rules, which
I'm sorry.
are.
I'm
Yes.
sorry. We have an audibility issue going on here. And there's a echo, a little bit of distortion in your speech. It may help if you are closer to the microphone on your device. It may help if you have headphones with a microphone attached to them. You can try plan A first if you like.
How's that? I'm a little closer to the mic. Is that better?
Court reporter's nodding yes.
Okay.
I'm not sure it'll stay yes, but try
Let me
to stay as close as you can there.
Will do, sir. Thank you. So the 5 reasons. First, admissibility of the experts would not be granted at the expense of the state's ability to cross-examine the testifying experts who authored the reports, fulfilling the purpose of the hearsay rules, which are generally to preserve the reliability and trustworthiness of evidence by limiting the admission of out-of-court statements made by persons who are not subject to cross-examination. Relatedly, the reports have been made on behalf of the accused, thereby not threatening his Sixth Amendment rights to confront witnesses against him. Second, indeed, state. How's the? There's reverb.
It's not great.
I'm going to dial in. Turn off my mic.
Do you have 2 devices going at once?
No, I'm not sure why it's doing that.
Ms. Foster, are you having the same issue I am?
Right. It's bouncing. His voice is bouncing.
If you're trying to telephone the Zoom link,
Yes.
I guess you can try that. I've experienced additional problems with that in the past, but feel free to try. I may not have provided you with an East Coast number.
There's one for New York, Chicago. No.
Your Honor, would you mind if I step away for a second while this gets resolved? I'll be right back.
Of course.
You are in the meeting now. There are 8 participants in the meeting. This meeting is.
How's that? Oh, yeah.
You'll have to leave the computer audio if you're going to use your phone.
That should do it then.
Okay.
Is that better? Is there any reverb?
Yes.
Sounds better.
Okay. My apologies for that. I will pick up from the second point. The first point about
I need you to hold up.
cross-
Hang on.
Yes,
Wait till the state's lawyer returns, please.
that's right.
I'm going to step away just a moment too. I won't be long. So before we resume, there's a little housekeeping update I need to share with you. As I've mentioned to you before, I have to attend to another matter at 1:30, another Zoom hearing on my private account. I think now that that's only going to occupy me from about 1:30 until 2. So, I'm going to estimate that and tell you that we're going to resume at 2:15. Since I'm going to have 2 Zoom hearings open at about the same time, I'm not sure what kind of complications that's going to cause. I may have to shut this one down, but we'll work through that later. All that said, we've got about 30 minutes to work here, and I'd like to use it. So, Mr. Campos, you can resume.
Thank you, Your Honor. In brief, my first argument was about granting would not be at the expense of the ability to cross-examine the testifying experts who authored the reports. The second point, the state has had ample time both to review applicants' expert reports and to prepare to cross-examine their authors. Third, Your Honor, admissibility of the expert reports in this case may be granted for the fact that this is a non-jury trial, reducing, if not eliminating the potential for prejudice to or abuse by a jury as to any hearsay evidence. Fourth, admissibility promotes judicial efficiency. Testifying expert reports provide a fact-finding court with guiding, important, sometimes complex, probative information in organized form. And fifth, admissibility of the expert reports in this case is justifiable pursuant to the court's wide discretion in determining admissibility of evidence. Lastly, Your Honor, we note persuasive authorities showing courts admitting expert reports, such as, for example, the Delaware Chancery Court and the U.S. Tax Court under Tax Court Rule 143G2, with the Chancery Court expressly echoing several of the reasons I've stated. For example, in re Comtech/Gilat merger litigation,
Spell the proper names there for the reporter. I've read the case, by the way.
Oh, all right. In re Comtech, COMTECH/Gilat, that's GILAT, merger litigation. The site is 2020 Westlaw 587-5155 at page 1. This is a 2020 case. As the court states, in my experience, parties typically agree to admit the reports of testifying experts in Chancery as a means to streamline and focus the trial presentations while also giving the fact finder important information that undoubtedly will inform the post-trial verdict. In my view, this is sound trial practice and it should be encouraged. The Chancery Court further noted, this court has also observed that an expert's report falls outside the definition of hearsay when the expert testifies at trial and is subject to cross-examination. So for these reasons, we request that the court admit applicants' expert reports. Thank you, Your Honor, and thank you for your patience with the tech.
Go back to point 1, please. I could not absorb it.
Yes, sir. First, admissibility of the expert reports would not be granted at the expense of the state's ability to cross-examine the testifying experts who authored them, fulfilling the purpose of the hearsay rules, which are generally to preserve the reliability and trustworthiness of evidence by limiting the admission of out-of-court statements made by persons who are not subject to cross-examination. And relatedly, the reports at issue have been made on behalf of the accused, thereby not threatening his Sixth Amendment rights to confront witnesses against him.
Well, I think we all know the state doesn't have a Sixth Amendment right it can assert here. The state stands on the plain vanilla hearsay rule. Other than the Delaware case that you cited and the rules in the tax court, can you point me to any state or federal decisions that have just come out and said, if the expert testifies, his report is then admissible by the proponent of his testimony, even in the absence of any charge of fabrication?
I cannot, Your Honor. If the court is willing to give me a little time to do additional research, I'd be happy to try.
As far as I'm concerned, this is an open question that's going to be with us for a while. But
Your Honor.
you'll note that in my ruling, I said that these expert reports, all of these out-of-court declarations are not admitted at this time. They may become admissible later, but without more, just standing alone, just as a document available now, I'm not sure that the rules of evidence that bind this court allow me to admit them. But having said that, I defer to Ms. Ventel.
Yes, Your Honor. The state's view, this is not an open question. A declarant's own prior out-of-court statements are still hearsay. If that was otherwise, there would be no point to 801E defining that prior statements must be only offered for inconsistent purposes or offered in to rebut a charge of recent fabrication, as Your Honor pointed out a second ago. There wouldn't be any limitations on it if all he has to say is, I said this before. Further, there would be no point of having a refreshing the recollection exception. There is a way that he can testify that there's something in the report that he forgot to mention on direct examination. That is up to applicant to bring that evidence out. There would be no point of refreshing his recollection if all he had to do was just read his own report. There also would be no point of past recollection recorded. This doesn't apply directly to an expert because obviously his report is not something he observed, but all of these exceptions clearly show that just the fact that a witness has said something out of court and is there to say it again doesn't mean that it means a hearsay exception. Further, this does apply equally to expert reports. The CCA addressed a similar issue in Martinez v. State. And the cite for that is 22.
Just a moment. Go ahead.
The site for that, Your Honor, is 22 SW 3D 504. And it's a 2000 CCA case. And in that case, they discuss its plurality opinion in Aguilar v. State. And in that, they noted that the present opinion of testifying witnesses can never be, by definition, a statement other than the one made while testifying. But that is directly dispositive on whether the underlying report he's relying on was admitted is hearsay or not. So just because he's testifying, that gets to the cross-examination point that they were raising earlier. He's certainly permitted to say anything that he said before as his opinion, but he can't just rely on his prior out-of-court statement. And if they move to admit it, it's hearsay. In that case, they did not move to admit the underlying statement, so there was not a hearsay problem with the prior report. That is exactly what has been argued here. I don't know if I gave a pin site for that, but it's 508, Your Honor.
Mm-hmm.
And to the argument that hearsay rules should be relaxed just because it's a capital proceeding, that's a stock argument that's been raised in every single post-conviction capital case. And it's continuously rejected. Those cases that they are citing to do not stand for the proposition to which they are citing. Kansas v. Carr, the Supreme Court has made absolutely clear that it is not the role of the Eighth Amendment to establish rules governing the admissibility of evidence in capital cases, whether that's sentencing or not. The rules of evidence apply. And certainly neither Chambers, nor Green, nor Sears, nor any number of other cases that they have cited in their response say otherwise. Those cases are entirely inapposite. They do not stand for the proposition that a court is free to disregard the state's own evidentiary rules just because it's a capital proceeding. He must show a hearsay exception. That he does not even try to shows that it's hearsay.
So here's a question for you, Mr. Campos and Mr. Robbins. These, well, perhaps, Mr. Campos, you're only addressing the expert witness reports. Is that true? As opposed to all
Yes,
the
sir.
out-of-court declarations?
Correct, Your Honor.
I'm assuming that all of these people, these that have been identified as experts, will testify during the hearing. And so the admission of these previous reports they'd made would to some extent be duplicative, would duplicate their testimony. Maybe not in every detail. But to get to the point I'm trying to make, surely the applicant can't expect that I would today admit all these expert reports into evidence. If no sponsoring witness, no nothing other than the fact that they're a quote declaration, perhaps. Would you have me admit them now Is that what you're asking me to do? Or are you asking for a ruling about their admissibility after these people testify?
Yes,
Yes, based on the first argument, the answer would be that it would be contingent upon them testifying and being subject to cross.
Right. Very good. So my ruling remains the same. I'm open to revisiting it at any time, provided somebody can convince me that Texas case law or some superior federal authority says that it's permissible. I agree with the Delaware court that obviously it helps conserve judicial resources. And obviously the declarant is there to be cross-examined about his statement at length. And obviously it would help the fact finder at some point to have access to all of the written analysis that that expert speaks to. But as a pure technical matter, I think the state has the better of the argument that these out-of-court statements constitute hearsay that's not admissible unless they come in for some reason after the declarant testifies. Apart from the fact that he simply says, I re-endorse this statement that I've made, and it's all true. Got to take more than that, as far as I can tell. Practical experience has shown that these reports almost invariably wind up getting into evidence somehow, usually by no objection, because both sides want them into evidence for some reason. All right, so I've said all that needs to be said, I think, about the expert reports.
Understood. Thank you, Your Honor.
Thank you, Mr. Campos. Appreciate your participation. What next? Mr. Robbins?
I think to the rest, if there are other, I think we would, subject to revisiting other things that were not admitted, we take up if when we tried to offer them. And I think that sort of finishes our pre-application, pre-hearing request for ruling.
I apologize for the yellow hand that appears on the screen. I plead not guilty to producing that.
You're not giving us a high five.
Nor am I telling you to get out of here.
Thank you.
I'm going to press the lower hand button.
Your Honor, if the applicant has nothing further, the state only has a couple very quick housekeeping matters to take up.
Go ahead.
First, the state just wants to ensure that Friday's YouTube video will be posted to your account.
Friday's YouTube video will be posted to my account. Today's YouTube video was live streamed. I can't remember, frankly, whether I engaged the YouTube live stream for Friday. But a recording was made of the entire day. So that exists.
Okay. Well, I guess depending on, I don't recall at this time either whether it was streamed, but if it was, and the court just would like to post it to its webpage, the state will be happy with that, just so it can access it. If it was not, then the state would request a copy of the recording.
So the YouTube, well, the simplest thing to do is to provide both sides with a copy of the Zoom recording that was made. Now that's a little technically challenging, I've found in the past, but I'll do my best.
Okay, and the state's next question was, the court has obviously been provided with electronic copies, and this is also a question for, I guess, I'm not sure who's going to be the court reporter on Wednesday, but the court was provided with electronic copies of all the parties' exhibits. Would the court also like physical copies at the hearing?
Ms. Foster, are you going to be reporting?
I believe it will be Sherry. She'll be back.
I think you're going to need to prepare to present physical copies.
Okay. Would you prefer a copy for Your Honor as well as the court reporter, or should we just plan on giving one to Ms. Stevens?
I'd like a copy.
And I apologize, Your Honor. Are you saying Your Honor, would you honor like a physical copy of all the exhibits as opposed to a sort of thumb drive?
Thumb drive will be perfectly adequate.
Thank you.
Okay, Your Honor, and the state only
Now,
has, oh,
you
I'm
can,
sorry.
you can confer with the reporter about that as well. Could be that a thumb drive of the exhibits will be perfectly fine. And she, it could be inclusive of all the exhibits, irrespective of my ruling about admissibility. And when the record goes up, she can indicate what's admitted and what's not, or print them out. However she does that.
In my understanding, the way that would work sort of logistically is that would, at the end of the proceedings, we give a thumb drive of what was admitted.
Not necessarily. I mean,
Okay.
I suppose that each side would want to include a copy in the record of everything that each side offered. And what I admitted or not, what I failed to admit could be subject to some review by the reviewing court.
Okay.
That's the only way you get the problem or the complaint about failure to admit before the reviewing court.
And Your Honor, just to be clear, the state's understanding of that process would be that the parties could move to admit those as an offer of proof, and then they would appear on the record.
Yes.
Yes. And then if that's all on the files, the state has the last matter. Okay. The last matter from the state is just that Mr. Chuck Canfield, who was the husband of Mrs. Susan Canfield at the time that she was murdered, he is requesting to be present for the testimony in this case. He's attended every trial and every pre-hearing throughout the whole time. And Mr. Canfield has been listed as a witness on the state's exhibit list. So that is the reason that we're asking for permission to allow him to appear. As Your Honor is well aware, the rules of evidence, including 614, exclude victims of the crime from the invocation of the rule. And he's also permitted under Code of Criminal Procedure 36.03. So the state would just request that Mr. Canfield be permitted to sit in throughout the entirety of the trial, or the hearing, excuse me.
Yeah,
Sure, Robert.
Quickly, I mean, obviously, what we would say is that's fine if they don't call him as a witness he's on their list as a witness to talk about events that happened at the trial, his memory and observations of events at the trial. I think the rules don't sort of contemplate the kind of way that they are offering him. It's not as if he's going to offer victim impact about how Officer Canfield was important to his life. They are offering him to put him in the mix to talk about the events at issue, and it seems unfair and not what the rule of witnesses contemplates for this kind of exception. And so we would be fine with it if they do not call him to testify about the events that are issue.
Your Honor, if I may, the rule does contemplate a victim being a witness. It's why they explicitly are enumerated as exceptions to the rule. There is a qualifying statement, and that is that if the court determines the testimony would be materially affected by hearing the other testimony at trial, we would submit that they do not. We have contemporaneous documents, and Mr. Canfield has already, it's his memory of just what happened at the trial. But the rules do specifically contemplate this situation, and he is permitted by right to sit in as the victim of a capital murder.
So I gather from that the state intends to actually call him as a witness as well.
Correct, Your Honor. He's listed as a witness for these proceedings.
Well, he's certainly going to be allowed to attend. It's an open court proceeding. As far as him being able to testify as a witness, even though being present in the courtroom, I can't give a blanket approval about everything he might testify to, obviously. But if he has something material and relevant to say, I think he's permitted to remain in the courtroom and testify.
May we at this time, since the court is seeking a pre-ruling of this, and one of our objections was that their notice of what he's going to testify is so vague. I mean, what is the proffer that they believe what he's actually going to say?
What did the description of his testimony include? I don't have it before me.
I don't either, but I believe it was to his observations. Go ahead, Ms. Spindell.
Yes. It's to his observations of Mr. Falk during trial, his observations of Mr. Falk's interactions with the state, which is their central allegation that there was impropriety, and interactions between Mr. Falk and his standby counsel, which is another allegation of theirs that there has been some, manipulation or interference by the state. He's not testifying on the facts of the crime or anything else like that.
So repeat the citation about victims in a murder case being exempted from the rule.
There's two rules. One is Rule 614, which is the excluding witnesses rule from the courtroom. And that is 614D. And the other rule is Code of Criminal Procedure, Article 36.03, which I believe is the Victims' Rights Act. I'm sorry, Your Honor. I don't think 6403 is the Victims' Rights Act. However, the rights of a crime victim are defined in the Texas Constitution in Article 1, Section 30. The Crime Victims' Bill of Rights. And then I believe Chapter 56A deals with the rights of crime victims.
You have the Code of Criminal Procedure article in front of you.
3603 deals specifically with the invocation of the rule. And that on a party's request, a witness who for the purposes of the prosecution is a victim, close relative of a deceased victim or guardian. Okay, sorry, I didn't read the rule properly from the beginning. So the rule is a court at the request of a party may order the exclusion of the rule only if the witness is to testify and the court determines that the testimony of the witness would be materially affected if the witness hears other testimony at the trial. And that refers to the crime victims as well. And that is purposely trying to discuss 614, which is the invocation of the rule. And also there's the constitutional provisions, and then Chapter 56, I believe, of the Code of Criminal Procedure.
So
I'm sorry.
what does the constitutional provision say?
Give me one moment, Your Honor. Article 1, Section 30 outlines the
Is it-
rights of,
It's okay. I have it open now.
okay. The relevant provision would be B2, Your Honor.
Yes, I'm reading that. Do you think that adds anything that's not already included in Rule 614D or Code of Criminal Procedure 36.03?
They appear to me, at least on just first glance right now, to be largely very similar. It's not mandatory that they be permitted to testify. It's why the state is making the request. And obviously it is up to the court to determine that his testimony would be materially affected, but it's only upon that determination that he can be excluded, is how I would summarize all of that.
Has he made a prior statement about these facts that he's going to testify to?
He is not, Your Honor, because they are what occurred in 2017. And he did testify in this case, but at the trial, but not related to, obviously, it wasn't relevant at the time what Mr. Falk was doing or saying or how he was acting with the state or anything like that.
All right, Mr. Robbins, you have something else you want to say about this problem?
I guess, I mean, again, just, the court might be able to, no problem with him attending, obviously. the problem is his testimony. I think the court could exclude it as cumulative because based on their notice of what they're offering, it may be just repeat what several other witnesses say. I don't know if this is doable, that he could be required not to participate to be in the court when witnesses are testifying about the same subject, and not to, but I think he'd be affected by hearing the other proceedings, so I take that back. So I'm just going to stop there.
So I'm going to allow him to be present. I'm going to allow him to testify to matters within his knowledge. And if the applicant at some point seeks to bar him from testifying, then they'll have to carry the burden of showing that his testimony would be materially affected by being present.
That's the last matter from the state, Your Honor.
I'm thinking. In fairness to both sides, I'm going to reveal to you that I have some concerns about this case that you might want to work to address. My concern is that the 2017 trial took place under circumstances that were clear to all the participants and can easily be inferred from the record that Mr. Falk had decided he was going to make no defense and let the process result in his execution. I have a concern about whether given that the trial court and everyone involved in the case was aware of his resignation to that fact, or to his fate, whether the court should not have intervened and denied him the request to proceed as his own counsel or without the benefit of counsel. it begs the question of whether this result amounts to the state of Texas participating in a suicide by jury. As a legal matter, I'm curious to know what courts have addressed this problem. I'm aware of a decision from the New Jersey Supreme Court that speaks to it, but not others. And as I think back, frankly, this may have been addressed in the applicant's application or the state's response. It's been so long since I read those that I'm unsure. But to be clear, I've not reached a conclusion about that. I have not made up my mind at all, but it is something that's very much on my mind. And of course, it'll ultimately be a decision for the Texas Court of Criminal Appeals or some federal court to make. But I'll be called upon to make findings and recommendations. Another thing that I'm curious about is the state's reliance on the fact that this man, quote, pled guilty, close quote. I'd be curious to see what document was admitted, in other words, what his judicial confession consisted of. So far, I've only seen a vague reference to it, including the terms, quote, as a party, close quote. It raises the question in my mind about even assuming or to put it another way, even disregarding the issue of deliberate plea of guilt. How could and even assuming adequate mental health competence, if you will, how could he possibly know what as a party meant? All right, that will give all of you something to think about for the next couple of weeks. These are questions that I need answers to.
Your Honor, would the court like a citation to the record on the guilty plea memorandum?
Do I have the record?
I don't know the answer to that, Your Honor. The clerk's record that went up on appeal, I'm not sure.
You're welcome to provide me a copy of it. I'm sure that, well, I suspect there's not going to be any objection to me reviewing that.
There is not, although given the discussion before about the prior proceedings and those being entered, but no, I mean, I'm not at this moment.
So you have no objection to the state providing me a copy of the plea papers in case number 2, trial number 2?
I guess I would need a moment to sort of soak in and digest the judge's ruling on that you can't look at the first transcript. And take notice of that. So I mean, normally under normal circumstances, I'd be, no, of course. But just that you've raised sort of these questions in my mind. It
Okay,
just almost
we've got plenty of time to think about this. State, why don't you extract the document we're referring to, send it to opposing counsel, and see if y'all can reach some agreement about whether I should be reviewing it or not. It's some strikes me that at some point it's going to be a part of the state's defense.
Right.
In any event.
I understand what you're saying. I mean, under normal circumstances, I'd be, of course not, but of course it's fine. But given that I'm still trying to sort of digest the court's ruling about taking notice of other matters.
All right, if there's nothing else today, I'm about to close down.
Thank you.
Thank you, Your Honor.
All right, good day, everybody.
Thank you, Judge.